Hear ye, hear ye, hear ye. All persons having business to bring before this court, withdraw here, give your attendance, and shall be heard.
Thank you. Please be seated. The first case on for argument today is case 504, People versus Everson. Okay, we have both counsel here. Counsel, can you hear us?
I can, Judge. Can you hear me?
Yes.
Can you hear me?
We can. Very good. Please proceed.
Thank you, Your Honor, and may it please the court, Peter Banishak for Mr. Everson. I'd like to address the first 2 points in our brief this morning, unless the court has questions about any of the other points. With regard to point 1, the lower court here erred in granting the out-of-order peremptory challenge, and that error was prejudicial under the circumstances of this case. First, I'd just like to address the argument made in respondent's brief that this was not an out-of-order peremptory challenge, and instead the court reconsidered its earlier denial of a for-cause challenge. Our position is that that argument does not find support in the record, as the court was announcing that the juror at issue was going to be the first alternate. The prosecutor said, "We'll use a perempt." It then explained that the prosecutor then explained that it had attempted to challenge that juror for cause. The lower court granted the belated peremptory challenge. It gave no indication that it was actually reconsidering the earlier denial of the for cause challenge. Either way, I do believe that it is an error. The respondent's brief does not cite any case law which would permit even an out-of-order causal challenge under these circumstances as an essential end run around the strict procedure for the use of peremptory challenges. With respect to...
Counsel, before you move on, does it make any difference with regard to this juror issue that they never got to using any of the extra jurors that they had, that the person that was in that seat never was called upon to be part of the decision making here?
It doesn't matter, Judge, under the circumstances of this case. I think the circumstances here are analogous to the circumstances in the Court of Appeals decision that we cite in our brief, People v. Kern. There, the court essentially held that where a trial court makes an error with respect to a peremptory challenge, even if that juror that the error was made with regard to does not serve on the deliberating jury, the error can still be prejudicial if the error impacted defense counsel's selection of other jurors, or even if it may have impacted defense counsel's questioning of other jurors. And in this case,
but counselor, but that's when the jury is still being selected. And here, and what Justice Bannister is referring to is the panel's already been selected. Now they've moved to the alternates. So why does that matter?
Because in this case, we had a situation where 2 jurors during the course of the trial engaged in, I think, what's charitably described as improper behavior, in that 2 jurors had an interaction with a testifying witness. In the middle of that witness's testimony, the one juror indicated that he sort of made a joke to Detective Shikalski along the lines of, well, take a break a little longer so that I have time to go to my truck to smoke a cigarette or something else. Under those circumstances, defense counsel may have wanted to engage in further questioning to determine whether these jurors should be replaced by the first alternate in light of their misconduct, but because the first alternate was not who defense counsel wanted in the first place, then he may have reasonably determined that, you know what, I'm not going to push this issue because the first alternate that the court sort of imposed on us is not who I would want to serve on this jury. And given those specific circumstances that are present in this case is more like People v. Kern, and unlike the 3 cases cited in respondent's brief, none of which involved a situation where defense counsel's questioning of prospective jurors or other jurors that could be replaced may have been impacted. And as a result, again, under People v. Kern, I do believe that there is prejudice here, or at minimum, the issue is not moot. Moving
But
on.
everything, counsel, everything you just said was sort of speculation, though. I mean, there's no real proof in the record, is there, that any of those thoughts entered, into the mind of the prosecutor, defense counsel, and they certainly didn't say anything about him on the record, right?
It's true that they did not say anything, but Judge, to the extent that it can be characterized as speculation, I don't think it's any more speculative than the situation in People v. Kern, where the Court of Appeals wrote the defense questioning of these white prospective jurors, some of whom did serve on the jury, may have been inhibited as well. May have been inhibited. Again, here it's may have been inhibited, and my recollection of Kern is defense counsel did not say anything about his questioning being inhibited as a result of the court's erroneous decision. So I think if it is speculation, it's no more speculative than Kern, but in the end there is a record-based harmlessness or lack of prejudice argument here in light of this improper behavior engaged in by those 2 jurors. If those 2 jurors did not have that interaction and there was no opportunity that counsel would have had to question any jurors, then I don't think I would have any argument. I think this argument would be foreclosed by the 3 cases cited by the respondent. But in light of that situation, our position is that there is a prejudice argument.
I think we have that argument. Counsel, you want to move on to point 2 and be mindful of your time?
Sure, Judge. I'd like to make 2 points with regard to point 2. There's no dispute here that the government committed a discovery violation. The only question is whether the remedy was appropriate and proportionate per the language of the CPL.
The request for the adjournment was not a request for a day to review documents, which we sometimes will have before us, those kind of cases. This was to go out and hire an expert. How does that make it a different case? In other words, the delay was going to be much longer, correct?
I imagine that the delay would have probably been a week or 2. The respondent's brief characterizes that potential delay as an undue burden. I'm not sure why it would be an undue burden, though, because we're weighing a defendant's ability to challenge the evidence against him. There was no indication that in
other words, if you're talking about the inconvenience of the court and the jury versus the inconvenience to the defendant and being able to defend against this case, the balance ought to be weighed heavier to the defendant. I understand that argument. Maybe a separate judge, and maybe one of the judges on this panel might have made that decision differently, but it's an abuse of discretion standard, right? That's what we're dealing with.
It is, Judge. A few points there. One is the respondent's brief relies on 4 cases that upheld an adverse inference instruction. I think it's critical that in all 4 of those cases, the court considered a situation where evidence was lost, never to be found. So there was no reason to offer an adjournment or any other remedy. An adverse inference instruction is all that can be provided under those circumstances. However, we have evidence that was belatedly turned over. And under the new language of CPL 24580, the remedy has to be both appropriate and proportionate. And if the prejudice is that the defense did not have an opportunity to consult with an expert, then the proportionate remedy, the remedy that is tailored to the specific nature of the prejudice, is to give the defense an opportunity to consult with an expert, or at least to advise the court that
What about, counsel, what about the court's offer on a 330-30 application post-verdict if needed?
Judge,
That seemed like a remedy, possibly, no?
I have to respectfully disagree, Judge. A 330-30 motion would have been available to defense counsel regardless of whether the court offered it. That's the first point. The second point is that on a 330-30 motion, the burden shifts to the defense to establish that the result would have been different but for this error. That's different from the burden that's on the prosecution to turn over evidence, which the defense then has an opportunity to utilize. And so in that regard, for those two reasons, that's both no remedy at all. And if it is considered a remedy, it's simply insufficient to address the prejudice that was caused by this discovery violation.
Thank you, counsel. Anything further?
No, Judge, thank you.
Appreciate it. Counsel, proceed.
Good morning, Your Honors. David Bassett for the people. As to opposing counsel's first issue, we submit the court did not abuse its discretion in granting people's challenge to this prospective alternate juror. The record supports a finding that this was a for-cause challenge and not a belated peremptory challenge. Although the prosecution attempted to make a belated peremptory challenge, the court, I think, denied that challenge. And then the prosecution counsel explained that's why we tried to cause him, and as in challenge him for cause. And the court immediately responded, I'm going to allow you to do it. I think a reasonable reading of that is that I'm going to allow you to use that challenge for cause. And even though this was sort of later in the game, the court always has the, I think, discretion and responsibility to maintain that the jurors are qualified and able to serve. And this particular juror had expressed disinclination to serve due to his work obligations. And therefore, I think the record supports finding that this was a challenge for cause, and the court did not abuse its discretion in granting it. And I do believe that the claim is also moot because this was a prospective alternate juror. This juror was never seated and did not participate in deliberations. I would submit to you that the People v. Kern case is distinguishable because it did not involve alternate jurors. As Your Honors were indicating, in that case, the panel was still being seated, and the court found that a ruling after only 6 jurors had been selected that Batson procedures would be applied to the defense affected the selection of all the remaining jurors that were seated and participated in deliberations. It's not the case here. This alternate juror was never seated and did not participate in deliberations. In defense, the appellant's arguments about that juror potentially being seated are simply not supported by the record. There was one innocuous exchange where 2 seated jurors asked one of the people's witnesses if they had time for a smoke break. The court inquired as to these jurors if there was anything else to that conversation and if this conversation affected their ability to serve as jurors, and they, of course, said that it did not. Defense counsel did not have any questions and did not follow up on this issue, and any effort to excuse these jurors based on this innocuous exchange would have been futile. Therefore, we submit that there was simply no reasonable possibility that this alternate juror could have ended up under the jury, and therefore defendant's claim is moot.
You don't think, counsel, you don't think there's a reasonable possibility that defense counsel under those circumstances might have challenged more vigorously the conversation and inquired more and pushed harder with the judge to have the juror removed if in fact the alternative juror that was going to be seated was somebody that he was more favorably inclined towards? Isn't that part of trial work? You judge, if you view what's coming, who's going to take this seat if I push really hard and knock somebody off? And I now have to balance. Do I go with this juror or do I fight to get that juror? And doesn't that not impact on the trial attorney's decision making?
I think it could impact trial attorney's decision making under different circumstances where there was more substance to the alleged juror misconduct. Here, there was literally a couple sentences exchanged which had nothing to do with the case.
Have you ever been involved in a trial where an objection sounds like it has no substance, and then after argument, prolonged argument, it gains substance?
That could be possible in some situations, Your Honor, but the court explored the issue, and I don't think any further inquiry by the defense, by defense counsel, would have led anywhere.
Well, that's the question before, so I understand your argument. Thank you, counsel. You want to move on to point 2?
Yes, Your Honor. Our position is the court did not abuse its discretion in tailoring a remedy for this belated disclosure. That remedy was an permissive adverse inference charge to the jury that they could basically infer that these materials, which Detective Sokolsky relied upon, would have been favorable to the defense or provided information that was not consistent with this testimony. I would submit that this remedy was more than enough to address any prejudice to the defense. Defense really making a mountain out of a molehill here. There was testimony from Sokolsky about this fingerprint identification process. He turned over a report and his notes, which showed his process and his conclusions. And the additional materials he relied upon were really would not have added much more to the analysis and may have even bolstered his testimony. And keep in mind that the courts have said that any remedy must take into account the people's degree of culpability. And here, Sokolsky was asked for everything that he relied upon in making his analysis and reaching his conclusions. He said he turned over everything. We tried to get all of his documents. We exercised our due diligence. The lower court said we took the necessary steps, and this came up on cross-examination, that there were a few additional documents that he used. And the court properly recessed the trial, allowed him to get those documents, retrieve them, and produce them to defense counsel for their review. And they were able to question him about them. And as I said, the court imposed a adverse inference charge, which was appropriate under the circumstances. I would submit that this was very late in the trial, adjourning the trial for some indefinite period for defense to obtain a fingerprint expert would have been not just burdensome, but completely out of proportion with any potential prejudice, since none was shown or articulated. And this court has found in several recent cases that an adverse inference charge is appropriate under these and similar circumstances. Does the court have any questions?
Any further, counsel?
Nothing further.
Thank you.
Thank you, Your Honors.
Case 506, People versus Bonanza. I believe the appellant has submitted. Counsel, proceed.
Good morning. May it please the court, I'm Karen Mowers, Assistant District Attorney with Herkimer County. I'm here in response to the appellant's brief, which has been entered upon submission. I ask at this time if there are any questions by the court in regards to the appeal or the people's response.
No questions, counsel? Thank you.
Thank you.
Case 508 in the matter of Moses KB.
Good morning, Your Honors. May it please the court.
1 second, please, counsel, if you wouldn't mind. Sorry for the interruption there. Counsel Whiteside, can you hear us?
I can, yes. Can you hear me?
We can very well. Thank you. Counsel, proceed.
Okay. May it please the court. James Hobbs on behalf of the appellant Ezra Bell. I understand that Ms. Bates had to submit today, unfortunately, and I'll be very brief. I believe a lot of the substantive issues in this case were resolved by a prior appeal. And the sole issue sort of remaining is the family court's best interest of the child analysis for the dispositional order and whether or not a deferred judgment or deferred suspended judgment would have been appropriate in this case. We've argued that it would, as Mr. Bell was on the verge of being released and has made a great deal of effort to improve himself and be reunited with his children. Unless the court has any further questions about that, I'll just go to break.
I have no questions. No questions. Thank you. Counsel, Whiteside?
Yes, Your Honor. We of course argue that suspended judgment was in no way appropriate in this case, but unless the court has any other, and that this order should be affirmed and was completely supported in the record. If there's any questions, I'd be happy to take them.
No questions. Counsel, thank you.
Thank you.
Case 509 in the matter of Dream B. Counsel, I believe appellant submitted.
I thought there was one of the AFCs was,
The AFC is arguing, yes, but the initial appellant
Yes.
submitted, yes, very good.
I didn't see her on the screen. That's what I was
Okay.
reading.
Very good. Counsel Rana, can you hear us?
I can, Your Honor. Can you hear me?
We can hear you. I'd appreciate if you adjust your camera. Whoop,
Sorry.
that's all right. If you adjust your camera slightly, there you
Yes.
go. Now we can see you and hear you.
Great. Thank you.
All right, very good. Thank you. Proceed, counsel. Thank you.
May it please the court, Peter DiGiorgio for the appellant Clara B., who is the paternal grandmother. There's a single issue in this case.
She was more than the paternal grandmother, wasn't she?
I'm sorry, Your Honor?
She was more than the paternal grandmother. She was a custodian for the child.
Correct.
Okay.
And I think the issue is going to boil, as I mentioned, it's a single issue case. It's really a legal issue, is does that piece of paper, that custody order, under circumstances imposes responsibility, but does it impose a duty that under all circumstances, if that child is released to the care of another individual, and you, as a grandparent, don't take that child back, it subjects you to a neglect petition. The court is aware of the facts here, but what actually happened has to be kind of broken down. The child was raised for a significant long time by Clara. The child then was having some behavioral problems, expressed to go live with her mother and maternal grandmother, which she did for a significant period of time, multiple months. Thereafter, the child came back when that maternal grandparent and mother was having difficulty with behavior in school and attending school. Clara, my client, took her back into her care, was having problems with her. Behavioral problems, leaving the house, not going to school, and she was accepting services. Clara did most everything, accepted ICANN services. There came a time that the child then wanted to go back and reside with the with the father. She went for a visit with the maternal grandmother. The father picked her up from the maternal grandmother's home and kept her. CPS was involved at that stage. My client was open that the child is now living with the father. CPS checked on the father's residence. That was short-lived. The father ends up dropping her back off at the maternal grandmother's residence. So the legal issue becomes, Nicholson versus Scott Pett is very clear. There's got to be some act that places a child in imminent danger of some type of harm. What my client did was essentially acquiesce in the child's wishes to allow that child to stay with other relatives that she had resided with in the past. So the issue becomes, I think it's a little bit different standard for a parent. There's case law that I cited in my brief that if a parent drops off a child with a relative, child stays with their relative for a prolonged period of time and doesn't take the child back, becomes an issue. Courts have held that could constitute neglect. But here we have a grandparent that just didn't drop off a child, and then the caretaker said, well, we can't care for this child. We're only supposed to have a child for a weekend. Several months went by, and there's nothing in the record to say that these other caretakers could not care for this child, but for the child's behavior. So I go back to my beginning statement. Does that custody order put a duty on a grandparent that once you take custody of the child, no matter what, that child goes out of your care for whatever period of time, and that person wants to wash your hands of that child, you have to take the child back or it's neglect. And we don't focus on what are the circumstances. I can offer you this example, and it's kind of a harsh example, but this is the slippery road that we face if we take this position that DSS took and that the judge took, that order of custody is essentially an obligation that you have to take the child back. I'm a parent or I'm a grandparent.
So let me ask you a question though. I mean, isn't that the essence of the order of custody? I mean, people seek an order of custody, they get custody. That is an obligation.
It is an obligation.
It's a very serious obligation.
Yes, it is.
Right? And so the idea that once you have that legal order that it imbues you with rights and responsibilities, you have an obligation to care for that child.
But Nicholson versus Scarpetta focuses on actions or inactions that place the child in imminent harm. Let me offer this example to you. I'm a grandparent that I'm involved in a relationship that now there's domestic violence in my house. Okay. I have a grandchild living with me. I don't want to disclose it. I don't want to do anything about it, but I pawn off my grandchild to another grandparent, the other side, to care for that child because I don't want to expose my child to domestic violence, but I don't want to bring it to court either. I want to work on my relationship. That grandparent then calls CPS, says, we can't care for this child. Now it's incumbent, it's a public policy issue. Sure, I could take back the child and expose that child to domestic violence in my house. Or
well, if in your, and I think I'm following your suggested analogy here, but in that situation, you got a child who's going to be exposed to this violence at home. So the parent or the guardian is doing a responsible act by removing the child from that circumstance, but has to do a responsible act by removing them into a circumstance where there's a responsible adult and somebody who's willing to take them, not somebody who's going to take the child and then call Child Protective Services and say, this child's been dropped off here and I don't know why. I don't want the child here.
That's what happened here, essentially. The child went with the father. CPS checked out the father's home. For all my client know, the child was going to remain with the father. The father then dropped off the child back at the maternal grandparents' house. My client was having some medical problems. We got now a 13 or 14-year-old girl who's got issues at school, who's running away at night. So I think we put too much emphasis on that piece of paper, the custody paper, and there should be more emphasis on what actions. Clearly, Justice Whalen, if she dropped the child off to a parent who was a drug dealer, a drug user, who couldn't care for the child, yeah, that's an act that she put the child in some sort of danger. But here, she acquiesced, my client did, in the wishes of the child. The child wanted to live with the father, and she heard that the father picked up the child, and she let that happen. She had taken the child back one other time. So I think this is a slippery slope, and we have a lot of grandparents. I do a lot of family court work. We have a lot of grandparents stepping up. And now I'm going to have to advise the grandparents if there ever gets to be a situation where this child is incorrigible and ungovernable, and you let the child go live with someone else who initially agrees, even a parent, and they wash their hands, this is a lifetime responsibility for you.
Typically, they could go back to family court. That's what they're supposed to do.
And if they go back to family court and they petition and the other parent says, we don't want the child, then what does the grandparent do?
Then you file a JD or a PINT. You ask for the help that the child needs.
And she did do that. She did reach out. She had ICANN services. I guess why this is distinguishable, Judge, is that she did all the right things, took the child back one time, and then under her understanding, the parent was stepping up. Her son was stepping up and caring for the child.
Well, in this case, though, we know that the other household was an untenable place to be with the child's mother and grandma.
I don't know if it was untenable, Your Honor, but
Well, you know, the mother was a schizophrenic and the grandmother had a hard enough time looking after her own daughter to take in the granddaughter. And there's this other issue of failure to plan. Okay, you're a custodian, you need to plan for this child's future. And so action, I would call this maybe an inaction on her part to do that, to plan for the child's future.
I guess my response would be that, there are circumstances where, yes, if she dropped off the child with the maternal grandmother and the mother who was schizophrenic was living there, but DSS allowed that child to stay there for 7, 8 months without issue. So I don't think there was a danger. There's no imminent risk to that happening. The grandparents had visitation on the weekends. There was CPS involved for 2 years. And I guess the failure to plan is that DSS takes this responsibility. Like, if you don't get a child out of foster care, we can file a neglect. I would say that's permanent neglect. I would agree with you 100%, Justice Bannister. A parent has an obligation to plan, but a grandparent who's stepping in and helping a child who takes custody, are we putting that same burden on them?
Counsel, you make a very good point, and these are troubling cases for the very reasons that you're raising here in your argument. Thank you.
Thank you, Judge.
Counsel?
Thank you. May it please the court. This is an obligation that the grandmother took on. And when we start, she gets her custody order because there is extraordinary circumstances. So she has a legal obligation to make sure that this child is taken care of as if she was a parent. She is the responsible party, and the record reflects that she kept saying, I'll only take her back if X, Y, and Z. Well, that's not the nature of parental obligation, and she stepped into the shoes as a parent. And it's extremely concerning from the child's perspective that nobody essentially wants her. And everybody knows, it's undisputed, that she's got emotional issues, behavioral issues. And what more are we saying to a child when we say, well, you have to figure it out on your own because dad won't take you, grandma won't take you, and they didn't really go forward with a voluntary surrender or anything like that. I bring this up because now the court should be aware that my client was found to be a juvenile delinquent and is in a 1-year placement. So not only did she go into a placement in connection with the underlying proceeding here, but now she's in another 1-year placement. I don't know if any of it could have been avoided, but it certainly started her off. She wasn't a 13 or 14-year-old. She was 11 when the family court proceeding started. So I just would ask the court to affirm the decision, because there are other cases probably similar to this, and we can't set a standard that persons legally responsible for the care of children can just send them wherever they want and not look back. If the court has
Anything further, counsel?
No, thank you very much.
Thank you, counsel. Case 510, Paris M versus Helio Health, Inc. Counsel, can you hear us?
I can hear you.
And we can hear you very clearly. Please proceed.
Thank you. May it please the court, Stuart Mermelstein for the appellate PM. This appeal concerns the issue of foreseeability. And the initial question presented is whether defendant HHI, the property owner operator, made a prima facie case for summary judgment by establishing that the assaults of the plaintiff, along with her 2 friends, all underage, was not foreseeable. That was the defendant's burden. They did not meet this burden. The defendant was operating a facility, a supervised care facility, or supportive living facility for recovering drug addicts. And this facility, by regulation, was required, the defendant was required to provide residential services in a supervised setting. In this setting, the individual residents of the facility had no tenant rights. They could be removed at will. They could be moved from unit to unit. They were assigned units within the facility to sleep at night, but they had no rights that a tenant would.
There were curfews established, is that right?
Yes, very important. There were rules and regulations within the context of the necessary supervision that was exercised by HHI. That included an 11 p.m. curfew and a random contraband checks. Now, as to the 11 p.m. curfew, that was enforced on weeknights, but inexplicably, it was left completely unenforced on weekends, a fact that the residents, of course, knew. So they had carte blanche at the facility on weekends. As to the random contraband checks, the HHI asserts that, well, there was no evidence that contraband was found. Well, it was incumbent on defendant to make a.
Counsel, let me ask you this. Is part of your argument, just so I understand correctly, is part of your argument that had they enforced their own rules and actually done the random contraband checks, that by doing that, they would have foreseen what actually was to happen?
That's correct. And it's important to note that.
How? Explain that. How would, by doing the random checks, have resulted in their foreseeability being satisfied?
It's important to note that the principal assaulter was this Fleming. And he was not only he not only relapsed, he was not only using drugs, he was running a drug selling operation from his unit within the facility. If random drug screen or random contraband checks had been conducted, the inference is that this drug activity would have been ferreted out, and the ultimate assault of the plaintiff
Let me ask
prevented.
Counsel, just so I understand. So had they done the random checks and they discovered the drug selling operation, which is part of what you just, I think, explained to us, that by doing that and discovering that, that would have led to the foreseeability of what ultimately happened here in terms of the assault?
Well, what is foreseeable is that a resident or residents who are freely engaging in not only drug use, but drug sales on the premises, and you combine that with the lack of curfew, non-enforcement of visitor rules, that together makes it foreseeable that there's a drug-infused party on the premises where girls are sexually assaulted, as three individuals, assaulters convene in one of the units on the premises.
Counselor, is there anything in the record that shows that there were prior assaults or anything of that by either the individual who's accused of it or other residents?
Yeah, well, there is some evidence of residents being intoxicated, making threats of violence toward others, and a physical altercation towards residents. And we cite, I refer to footnote 1 of the reply brief, and we cite the various portions of the record that contain that. But I want to emphasize that we don't need to rely on that, because given all the facts and circumstances, again, it was defendant's burden to make a prima facie case that these assaults were not feasible. The defendant knew that there were risks involved in terms of residents harming themselves or others, and had rules in place to mitigate those risks. and then didn't enforce the rules on weekends. Those are the most salient facts. You can also combine that with the principle.
Aren't those rules designed to prevent alcohol or drug use? That's what.
Again, they're designed to prevent the residents' harm to themselves and to others, which is a known and inherent risk of drug use, of relapse for a drug addict. I also want to point out, very important, that the main perpetrator, this Fleming, he had repeated failed drug tests, and there's a serious question as to there's evidence in the record that if he continued to use, he should have been moved to a facility with a higher level of supervision. And he did continue to use, and he wasn't moved. So he was there. He shouldn't have been there. In fact,
your argument, counsel, it sounds like your argument is if they had done their job and satisfied what they were responsible for doing, then this gentleman, Fleming, would not have been in the apartment and this event would not have happened.
Correct. Fleming would not have been in the apartment, or he would have been under appropriate control to prevent
a higher standard of care. A higher standard of care would have been required of his care, and he would not have been in a situation where this harm would have happened. Is that the argument?
Correct. And the evidence shows that he was not allowed visitors at all in his unit. And here he had this whole party going on in the Saturday night, the weekend of Labor Day.
And that's your argument in terms of how it becomes foreseeable.
That's correct.
Okay, I think we have that argument. Anything further, counsel?
That's all.
Thank you.
Good morning, Your Honor's James Special for Helio Health. One of the first things I want to say, I don't know if anyone has had a chance to read it yet, but the Court of Appeals put out a case last month called Nellenbach. It's a CVA case. The defendant won 6-1, and plaintiff's argument here, I think, and I watched the argument in that case over the weekend, it's very similar. First of all, in these type of cases, plaintiffs have usually said, oh, for foreseeability, but they're suing for negligence. So what we're really talking about is notice. And there's a lack of notice here because, like in the Nellenbach case, which was also a group home, I believe, there were all these rule violations, and they were lax on the rules, this and that. There weren't proper notes taken of the residents, but the court kept coming back, okay, well, what does that have to do with sexual misconduct? So when I read that case, I think the bottom line is that if there's no warning or anything of sexual misconduct, that's basically it. Because all we really hear about here is, oh, well, he drug use. And okay, fine, but that doesn't mean that someone is going to go out and rape someone, right? Of course not. So, and that was kind of going back to a prior Court of Appeals case, Moore, where the gentleman, he's an alcoholic and he commits fraud, but the court in that case said, well, it's quite a leap to go from being an alcoholic to crimes. Like, not all of them do that, of course, most don't. So at this point in time, with this type of case, I would say if there's no history of any type of sexual misconduct, which there wasn't, not from just Fleming, but from any resident, then there's just not going to be no notice. And they may be able to say, oh, well, for instance, the curfew, well, right, okay, sure, but just because someone breaks a curfew, it's quite a leap to say, well, they're gonna do something like this, right? So I think that's where plaintiff's case ultimately fails in a nutshell. In particular, now that we have Nellen back, because it seems pretty clear in this type of case, and I've done a lot of them. This argument is what many plaintiffs do when there's not a history of any type of sexual misconduct. They always try to point to I've had alcohol, DUIs, things like that, violations that have nothing to do with sex. So, and with that case now, to me, it seems clear that if there's literally no history of any type of sexual misconduct, that's kind of it.
Anything further?
Nope.
Thank you, counsel.
Can I have a question? Would it be possible for me to address Nellen back?
No, counsel, you can post argument submittal is all we have, but you have an opportunity to do that.
Okay.
You can do it right in post argument. We have no rebuttal.
Thank you.
Thank you.
Yeah, this is the one we're moving.
Oh, yeah. Thank you.
Thanks.
There's my wing piece. That worked. Thank you. Case 511, Heartbeat International Inc. versus Letitia James. Justices Ogden and Greenwood are recused from this case, and Justice Nowak is kindly stepping in.
Excellent. Thank you, Your Honors, and thank you for your indulgence this morning with the calendar order. I very much appreciate it.
Not a problem, counsel. Happy to oblige when we can.
Thank you. It was an abuse of discretion to consolidate this litigation in Monroe County because it served to allow the defendant in an attorney general initiated civil enforcement action to use a preemptive strike to control where that enforcement action was going to be heard, and thus the allocation of the attorney general resources.
Yes, this is an interesting argument. Let me ask you this. We have a statute here at play which requires a 5-day notice period, right?
Correct.
Okay, so it was during that 5-day period, arguably, that the complaint was, the action was commenced, correct? And your concern is that by being first to file, that's going to determine where the venue is. But didn't the court below look at maybe not only that issue, but other issues that affect venue when making a decision? And isn't that the appropriate way to go about this? To look at all of the factors, how the witnesses, are there any expert witnesses, the attorney's convenience, those kind of things. When a court does that, I think the court's weighing all the appropriate things. And then it becomes whether or not how the court weighs it. I don't think there was an indication that the court below said, first to file, I'm done, case over. And that would have strengthened your argument, I think, had that happened, right? You'd then be able to say the court didn't do its job. But didn't the court weigh other factors here?
The court weighed the other factors, Your Honor, but there was a flaw in weighing those factors to begin with. If I could state our understanding of the law vis-a-vis venue and consolidation. Sure. When you have the context of consolidation, the court naturally has to determine where the venue for the consolidated litigation is going to be. That's going to be broader than the CPLR 510 factors, for instance. And the assumption behind that is that you have two bona fide plaintiffs, two legitimate plaintiffs with equal interests. And so when you have two legitimate plaintiffs, it makes sense to weigh a broad assortment of factors, treat them on equal footing, and really figure out which venue is superior, not just which is appropriate, but which is superior. Our argument about a departure from the first filed rule is that you start from the point that the first filed rule is the presumption. The one with the first lawsuit usually gets the venue of their choice. But if you have not always, and that's where those broad factors come in. Those broad factors, for instance, congestion, connection to the transaction, those could be factors to depart from that presumption under the first filed rule. Another basis to depart from that presumption is if you have a preemptive lawsuit designed to gain a tactical advantage, and where that departure is unique, and that it's that now the parties are on equal footing. If you're going to find that one party's lawsuit was this kind of preemptive strike, and you're still determining based on this broad discretionary review that one venue is marginally better, then you really are serving to reward the party that engaged in the preemptive strike. And that's why we put forward the argument that where a departure is warranted, as we argue it is here, the appropriate response is to disregard the first filed lawsuit, at least for purposes of venue, and focus on whether or not the venue of the second filed lawsuit is appropriate. The reason that we make that argument is because it serves to keep all sides honest. On the one hand, you're not rewarding the party who raced to the courthouse to gain a tactical advantage. On the other hand, you're not turning a blind eye to the second filed lawsuit. You're making sure, you being the trial court, that this action is going to be consolidated in the correct venue regardless. And imagine, for instance, there is no preemptive strike. The party that didn't file preemptively could always move to transfer venue under 510. So even under our understanding of the law, the CPLR 510 factors matter. If I could go back for a second and just really emphasize the point that this was a preemptive strike, and you had asked a question, Justice Whalen, about did the court really apply the first filed rule? And we argue the answer is yes, because when you look at the court's decision, it recognizes this principle of filing while our hands are tied, and then it engages in this analysis where it finds that their lawsuit really wasn't preemptive. It's the court reasons that they couldn't really understand that a lawsuit was forthcoming. So we understand that as the court finding that the departure simply wasn't warranted because this wasn't in fact a preemptive strike.
There's nothing in the law that says that if the court was to find, oh gee, this is a preemptive strike, that the court should react to that alternatively. The court should immediately say, well, because of the preemptive strike, then you lose venue. There's nothing that makes you lose venue. It's just something that you wouldn't necessarily follow the presumption, right?
That's correct, Your Honor, and that's
that's okay. And so my question really is more about the legislative history, about the general business law 349 and 350C, the requirement to file the notice of intention to sue. It looks like the purpose of that law is again to allow parties to maybe reach a resolution, to settle it so that you don't have to, so that the Attorney General doesn't have to sue. Is that correct?
Absolutely, Your Honor. The legislature itself, in the legislative history, it describes the 5 days as a cooling off period.
Okay.
It doesn't mean that litigation won't ultimately happen, but the goal is to allow the parties to try.
Is there anything that you found in the legislative history that also says it gives an opportunity for the party that may be sued to select the venue, because it gives them that opportunity in the meantime? Exactly what happened here, what you've called a preemptive strike, but in a given case might be appropriate because the investigation or the lawsuit might actually concern a particular defendant in a particular area where really it should be venued there, insofar as the state Attorney General's office has broad reach.
We've seen nothing in the legislative history that indicates that the legislature ever even contemplated the possibility of a preemptive strike. And frankly, in the many years that the waiting period has been in effect, our research has revealed only one case where somebody's ever even tried this. That's the Kaposia versus Spitzer case. That involved a party who filed an Article 78 upon receiving the notice of intent. The case that wound up in the third department wasn't about that per se. play because the Article 78 court summarily dismissed it, said bring whatever arguments you have in defense to the Attorney General civil enforcement action.
Okay, but you could envision a particular case, separate from this one, a hypothetical case where it should be venued in a particular county in the state because of the impact on the defendant in that particular case, right? But you even offered, you said, well, the defendant could make a motion under 510 and say, let's move it from New York County to this venue because everybody's here in this particular venue. You could envision such a case, right?
Of course, Your Honor. That's why we say that even under our understanding of the law, the CPLR 510 factors still come into play.
Okay, so why isn't this one that case?
Because the CPL 510 factors at this stage of the litigation, the earliest stages of the litigation, the HBI parties have fallen far short of making any kind of showing that venue in Monroe County would be appropriate there. You have two factors that might come into play, venue being appropriate and convenience to witnesses. They argue venue is not appropriate because it's not our principal place of business. Now, we do have one of our principal offices in Manhattan, but that's really beside the point. Principal place of business comes in under 503C. It applies to private corporations. The Attorney General, and as a government entity, residency for purposes of 503A is any county in the state of New York. And that makes sense. If you look at the caption of this lawsuit, it isn't James versus Heartbeat International. It is the people of the state of New York. By James. The people of the state of New York, on whose behalf we act, obviously reside everywhere. Yes, New York County is a convenient forum for us because everybody who worked on this case and has knowledge of the underlying facts worked out of the Manhattan office. Anybody who's outside the Manhattan office was assigned only in reaction to the preemptive lawsuit. And
what about Compass Care being here in Monroe County?
Compass Care is in Monroe County, but it also has a presence in Brooklyn. But under our conception of the law, if you're talking about the 510 factors, appropriate forum, we as the natural plaintiff selected the appropriate forum. So what we are asking the court to do is basically conduct the 510 analysis as though the preemptive strike hadn't been filed. So imagine Compass Care moves to
counsel, do we have to first determine that the trial judge in this case abused his discretion before we get to that?
Well, the entire standard of review would be abuse of discretion, Your Honor, and we do argue that there's an abuse of discretion here. The trial court seems to recognize that the HBI parties sued when our hands were tied by statute, but then the trial court engages in this sort of both sidesism. It reasons that it's a wash because we also, according to the trial court, that we rush to court and engage in gamesmanship by filing our own competing lawsuit and our own competing motion to consolidate. But the record does not fairly support that characterization.
Counsel, we may very well read the record the same way you do. But that doesn't necessarily get us to a finding that the court abused its discretion when the court did its own analysis of the record. Do you understand what I'm saying?
I understand that abuse of discretion is deferential, Your Honor, but when you look at the court's reasoning, when the court is accusing us of gamesmanship for filing our own lawsuit, that's the lawsuit that we telegraphed in the notice of intent. We told the HBI parties we were going to do it, and then we did it. With respect to the motion for
you told the HBI parties, as you earlier argued, you told them that you may do that, and there was a hope, which the legislature built in, that there was a cooling off period and maybe it would get resolved. That's not the same as saying we're filing suit, right? That's different.
Not particularly, Your Honor. And that's what your question is doing, is echoing Supreme Court's reasoning that maybe the notice of intention didn't really state our intent to sue. But of course, the language in the notice of intent about the 5-day period, come reach out to us, let's see if we can talk. There is no credible basis for the HBI parties to claim that they understood that if they didn't reach out to us and engage in these kind of discussions. And it says right in the notice of intent, engage with us in writing, send us a written reason why a lawsuit shouldn't be filed. There's no reason for them to think that if they don't do that, we're not going to sue them, that we're just going to go away. And they not only decline to engage with us by way of such a letter, they go and sue us when our hands are tied. So,
Counsel, this is a cooling off period, right? Is filing a lawsuit against you, consistent with that idea of a cooling off period?
absolutely not. It's the polar opposite of a cooling off period. It has escalated
Did they
matters.
engage at all with you as far as, discussing with you, ways that you could resolve this case short of suit?
No, Your Honor. They raced the court. They filed what is in essence a motion to dismiss a lawsuit that hadn't been filed yet. Their complaint is a motion to dismiss, except instead of asking to dismiss, they are asking the court to enjoin us from filing in the first place. If they truly believed that our lawsuit lacked a basis, if they were confident that it was a slap lawsuit, as they characterize it, they could just as readily have taken that same pleading, given it the appropriate label of motion to dismiss, and filed it in whatever form we wound up commencing our civil enforcement action. The question becomes, what was the pressing need to take this extraordinary step of suing when they knew we were about to sue them, but they knew that we could not sue them? And the only discernible gain to be had there was that they obtained the forum of their choice. That's why we characterize this as a preemptive strike intended to secure tactical advantage. They claim in their papers, well, we didn't have to sit on our hands, and maybe not, but they were supposed to engage with us. They weren't supposed to sue us. They might claim that they were trying to protect their rights, but we're talking about a period of 5 business days, and if they wanted to protect their rights, and once again, they were confident that they had a compelling basis to dismiss, all they had to do was file the motion to dismiss. With respect to the deferential discretionary standard, this court has not hesitated to find abuses of discretion in cases where the record just simply doesn't bear out the conclusions of the court. So one of these conclusions, that the HBI parties didn't have a reasonable basis to infer that we were about to sue them, that is just defied by the record. We could not have been clearer. We are going to sue you unless you do A. A being give us.
Also, counsel, we don't need to find there's an abuse of discretion. We can exercise our own discretion, can't we?
Yes, Your Honor. And in this instance, because of the preemptive strike, whether it's an abuse of discretion or exercising your own discretion, we would ask that you look beyond the preemptive lawsuit and, in essence, conduct the 510 analysis. If I could discuss some of those points, because we do raise
Counsel,
those.
we're running short on time, though, so certainly.
I can do it in abbreviated form.
Let's do it in abbreviated form.
So we already discussed appropriate forum. The other factor is convenience to material witnesses. The only potential witnesses they propose at this early stage are their employees. This court has said that's irrelevant to the analysis. Even if it were relevant, we can only speculate about materiality because they haven't identified any actual facts that they would offer. Again, not surprising. We're still in the earliest stages. And even inconvenience is speculative. We have the generality that Manhattan is far away and that it's expensive. We know that it's far away for some of the HBI parties, but not others. HBI itself is out of state. They're getting on a plane no matter what. As for expense, we have no idea who is ultimately going to appear in Manhattan and who's going to be footing the bill. What we do know is that there had been a parallel case in Manhattan and that they have appeared and they have defended their rights ably thus far. So I will close by emphasizing that this case isn't personal. We have nothing against Monroe County. We have nothing against Judge Valeriani. We litigate before him all the time. We are here in this court today defending a broader principle that it is the plaintiff, whether the actual plaintiff on paper or the true natural plaintiff, that ordinarily gets to set the terms for commencing litigation absent a motion to transfer venue under 510. And going beyond that principle, we argue there is a very strong public interest in not letting stand a decision that provides a roadmap to would-be targets of the Attorney General's enforcement efforts on how to game the system and put us on the defensive before the case has even gotten off the ground.
Thank you, Counsel.
Thank you.
Thank you, Your Honors. May it please the court, Christopher A. Ferrara for the plaintiff's respondents. My adversary has referred numerous times to a preemptive strike. I think the argument that you've heard is essentially this. The first filed rule should not be applied in this case because the plaintiffs filed first. It's really that simple. That's what they're saying. Why did they file first? Well, they filed first because the venue is reasonable. Two of the plaintiffs are in Monroe County. The rest of them are, the majority or almost the majority are in the 7th Judicial District. The rule in this department is that in a consolidated case, venue should be the county in which the first filer brought the action. Only in circumstances where you show aggravated conduct has that rule been departed from. So in this case, for example, there was no race to a courthouse in a different state as there was in the RDF agent case, or the certain underwriters case, or the AIG case, or the L3 communications case, or the white light case, all of which involved races to courthouses in distant forums. Secondly, there was no bare bones declaratory judgment filing just to get to the courthouse first. This was a massive protective First Amendment related filing involving a 66-page verified complaint, 7 supporting affirmations and exhibits. And I'll get to why it was filed at the time it was filed in a moment. So it was not a bare bones declaratory judgment filing. Third, there were no sharp tactics in this case. I point to the certain underwriters case where there was discussion about amending a complaint, which would have brought the defendant into the action. The defendant agrees to the amendment, and while the amendment is pending, rushes off to file a declaratory judgment action in New York to try to get the case out of Connecticut. Nothing of the sort happened in this case. Or the Platkin case, where the defendant negotiated for a 30-day extension of a subpoena, and then on the very last day of the 30-day period, when it promised to respond to the subpoena, brought its own minuscule filing just to get to the courthouse first. Or the white light case, where there was a lawsuit filed in California, hidden for 3 months, never served process, while talking settlement in the state of New York. Those are the kinds of conduct that would take this case out of the first filed rule. Nothing of the sort happened here, and the venue was appropriate, and the judge therefore did not abuse his discretion.
Counsel, let me ask you this. The claims between the parties before us, would you agree that the state, represented by the state AG, is the natural plaintiff in those claims?
No, I would not, because of the First Amendment context of this case, and that was my next segment. The notices of intent to sue under First Amendment standing principles represent a credible threat of enforcement of a speech restriction. And that credible threat gave us standing to bring an affirmative action against the very initiation of this lawsuit. And that is exactly what happened.
But that claim is in direct response to the initial claim that was being telegraphed to your client by the state, is it not?
Yes, but there's
So
nothing.
in that context, wouldn't the state be the natural plaintiff? In other words, it's a response to what the state is doing. That means the state is the plaintiff in the action. You're responding to what they're claiming they're about to do.
I don't believe so. I believe that we are the natural plaintiff in the First Amendment context, and I'll explain why. In Niffler v. James, which is the case coming out of the Western District of New York, there wasn't even a notice of intention to sue. The mere possibility that there could be a notice of intention to sue entitled those nonprofit organizations to go to federal court to seek an injunction against litigation as plaintiffs, First Amendment plaintiffs. And the judge agreed that the threat of prosecution of protected speech, and that's what we're talking about here, was sufficient to give these plaintiffs standing as affirmative plaintiffs, not just people who were not the natural plaintiffs, but actually First Amendment plaintiffs. And he granted a preliminary injunction. That is exactly the relief we sought in Monroe County. The judge did not abuse his discretion in finding the venue for the consolidated action appropriate, and there's no risk of inconsistent adjudications because this is now a consolidated case. So all we're really doing here is what the plaintiffs successfully did in Nifla v. James, and cite on that is 2024 Westlaw 3904870. And the judge in that case basically said this: the abortion pill reversal protocol, so-called, is being administered by doctors. Any woman can go to a doctor, ask for the administration of supplemental progesterone. Perfectly legal. The Attorney General can't enjoin that medical practice. So the problem here is that the Attorney General, unable to enjoin the practice, wants to enjoin, punish with damages as well, and compliance monitoring, speech about a perfectly legal medical procedure that's being administered in this state as we stand here.
Well,
So we are plaintiffs in the affirmative sense.
but my understanding is they felt that that speech was misleading and a threat to the public health. And so that's what gave them the ability to go and try to protect New Yorkers from those claims.
Except that we already have one federal decision that it's not misleading speech, it's protected by the First Amendment. And speech about medical issues that are freely debatable, ipso facto, is not unprotected by the First Amendment, but enjoys full First Amendment protection. So all we really
Is the speech connected to Monroe County or even the general area, the Seventh Judicial District, in a way that's different from downstate? Or is the message that Heartbeat International is giving, is it statewide? Are they trying to communicate this statewide?
Well, in terms of venue, two of the plaintiffs do reside here, and a substantial amount of the activity involved occurred in Monroe County. So venue is proper.
I'm sorry, you keep referring to them as plaintiffs, but they're not plaintiffs, correct?
Well,
The defendants.
now they are in the consolidated action only.
Yep.
Right, yeah, that's true, but only because of the consolidation, and we agreed to that.
Right, you consented to it.
Yes, we agreed to that. So then the issue is, because we were the first filers and because it's a consolidated action under the Varney rule, which is perfectly applicable here, there being no aggravating factors, venue in Monroe County is perfectly proper. And just calling it a preemptive strike over and over again tells you nothing about whether this court abused its discretion. Again, it's just another way of saying that these parties should not get the benefit of the first file rule just because they filed first. If that were the case, no one could ever get the benefit of the first file rule. You could always say that suit is a preemptive strike.
Very good. Counsel, do you want to start wrapping up, please?
Yes, and so again, because of the absence of any aggravating factors that would have allowed departure from the first file rule, there's nothing here in terms of Judge Valiarani's decision that constitutes an abuse of discretion and should simply be affirmed.
Thank you, counsel. Okay, we're going to welcome back Judge Greenwood and Judge Ogden, and we'll call case 513, Esperanza Mansion Group LLC versus Mellenbach. Proceed, counsel.
Morning, Your Honors. Kelly Foss for the appellants here. There are really two issues that are brought forth on this appeal. The first is to seek reinstatement of the willful exaggeration claim against Todd Alexander. And the second is to seek reversal of the denial of summary judgment. At just a very high level here, this case started with an oral agreement between the parties to contribute to and to jointly operate a company that the acronym is EMG. The Mellenbachers invested over $1 million of cash in exchange for their interests. And Todd Alexander and Mary Olivo invested their time and the services of Todd Alexander's company, Todd Alexander Enterprises, Inc., in exchange for theirs. except that Todd Alexander and Mary Olivo secretly arranged for Todd to acquire 100% equity interest in the operating company. The Mellenbachers never received any equity. This is not a matter in dispute. Once the venture was clearly failing, Todd and Mary caused EMG to abandon the premises. The Mellenbachers thus lost the investment that they had made into EMG, for which they'd received no equity. Todd Alexander and Mary, not wanting to lose their investment, decided that the Mellenbachers should pay them for their contributions to the entity, to Todd's own entity. Todd and Mary admittedly spent months creating invoices and preparing a mechanics lien to file on the property. They filed the lien and immediately sued to foreclose on it. In the foreclosure submissions on summary judgment, this was in 2021, they stated that the invoices were legitimate, that they'd been delivered to the defendants, that all of the charges on those invoices had been contemporaneously added into the QuickBooks account. And none of that turned out to be true. They have admitted that they generated basically all of it on the eve of filing the mechanics lien. I want to address, as the first point, the reinstatement of the willful exaggeration claim against Todd Alexander personally, because I think it's quicker than the summary judgment piece. First of all, the lower court here based its decision entirely upon the four corners of the pleading. The plaintiffs in this case, Todd and Mary, filed a motion to dismiss under 3211 of the CPLR. The court looked only at the four corners of the pleading that was filed in 2020 for whether there were factual allegations against Todd Alexander personally. But under the case law, I mean, at this point, that the case had been litigated for 4 years, there was a significant record. And as you'll see from the volumes we submitted a lot of evidence, including sworn statements and testimony by Todd Alexander to supplement the pleading. Under this court's decision in the Robert H. Law case, the court must consider the EBT testimony to supplement the pleading, and here that didn't happen. The respondents in this case, on this appeal, they haven't even attempted to argue that issue, and therefore they effectively concede it. Instead, they articulate two alternative grounds for affirmance, neither one of which was adopted by the trial court below, and for good reason. The first alternative ground they assert is that no person other than the lienor can face liability under lien law section 39-A. That is simply not a proper reading of the statute. The statute itself says that the penalties shall be imposed upon the person filing the lien. Other portions of the lien law use the word lienor, but here the legislature did not use the word lienor. They used the word person. And under general construction law section 35, statutes are interpreted with the singular also including the plural. So any person who participates in filing a willfully exaggerated mechanics lien can be liable under the statute just based upon straight statutory interpretation principles. Additionally important here is the Second Department's 2004 case in Greenway Plaza Office Park 1. In that case, the property owner asserted a willful exaggeration claim against a corporate lienor as well as its president personally. The plaintiffs sought to impose personal liability on the president for the corporation's allegedly tortious conduct and, among other things, improperly filing the mechanics lien. The lower court granted the defendant's motion for summary judgment as against the president, but the Second Department reversed, finding that because the conduct in willfully filing a mechanics lien is tortious in nature, if a corporate representative personally participates in that tortious conduct, then that person can also be held personally liable. So their alternative ground number one rejected by the lower court.
We'll take a look at that.
The second alternative ground they assert about Todd Alexander personally is that the pleading doesn't assert a claim against Todd Alexander. Now, this was not a preserved issue. It was never argued below, and so this court shouldn't consider it. But even if it does, we've cited in our papers a stipulation that was entered in the case and referred to in the decision below, where the parties listed each of the claims remaining in the action and who they were against, and the parties stipulated this cause of action was brought against Todd Alexander personally. And then finally on this point, I just want a point of clarification. The respondent's appellate's brief states that there's no tortious claim or no tort claim asserted against Todd Alexander personally. That's not true. There is an abusive process claim in addition to the statutory claim that's asserted against Todd Alexander personally. In fact, we were before the court on an earlier appeal in the same case. We had moved to amend the pleading to include that abusive process claim against Todd Alexander. Todd Alexander sought to appeal the insertion of that claim in the amended pleading, and this court agreed with Judge Odorizzi below that it was proper to include that in the pleading. Moving to the summary, unless anybody else has further
questions on that point. You should be mindful of your time, though, counsel.
Yes. So with respect to the summary judgment motion, I just want to emphasize that there is no need to look at any factual disputes on the summary judgment piece. The other important piece of this is the Court of Appeals in a case called Goodman. The site is 15 NY 2D 191. Stated that where there is any willful exaggeration, and italicized the word any in the decision, in the amount of the lien as filed, the entire lien is forfeited under Section 39 of the lien law.
Counsel, let's italicize the willful piece of this, right? The intentional act. And I know part of your argument has been that they came together and they started to manufacture these invoices just before they filed their lien claim, right? But isn't it usually a jury question on the issue of intentional? Isn't a jury in a better position to listen to the witness, gauge the witness, and determine whether or not those actions were willful? People can put together invoices that are legitimate invoices, or if they believe are legitimate invoices, and even though they had not been previously produced. And wouldn't that be a better question for a jury to answer as opposed to on a motion for summary judgment?
In the general sense, Your Honor, there are many cases where there are factual disputes about willfulness. There is no factual dispute here. And the reason for it is this. Our motion for summary judgment is based entirely on their own sworn submissions and their own accounting records. And what they try to do to oppose summary judgment is to contradict their earlier sworn statements. This court held in the Mann versus AutoZone case in 2017 that the court cannot properly consider submissions on summary judgment arguments that contradict earlier sworn testimony. Here, the Intermetal Fabricators case of the First Department, which was in 2021, I think is very much on point. In that case, the Appellate Division, First Department, unanimously affirmed summary judgment as to liability for willful exaggeration. And that was because the proof was based upon the lienor's own admissions as well as its own records of costs. And looking at the appellate briefing on that case, in that case, the contract was for time and materials plus a 10% markup. The records of the costs that were charged and then what was put on the actual lien showed that instead of a 10% markup, the lienor put a 15% markup. And when confronted with that, the president of the lienor testified, I shouldn't have been constrained by what my actual cost was. I could mark it up to what I wanted. Here, it's the exact same thing. They themselves testified multiple times that the contract was for costs plus a 10% markup. But instead of marking it up to 15%, as we put in through our unrebutted expert affidavit, their own accounting records show that the labor rates were inflated by 80 to 137%. In addition, the audit history reports And the admissions in their own testimonies show that they inflated hours as well. They had testified that their accounting records were accurate. They testified that any labor costs that they incurred would be in the payroll in QuickBooks, either under employee payroll or under vendors if it was an outside contractor. Our expert put in an unrebutted opinion, looking at their own accounting records. There were many labor hours that were not in their system at all. And now they want to try to say they shouldn't be constrained by their own records. They can't contradict their earlier testimony.
You should wrap up.
Yes, Your Honor. Trying to find a way to do this as quickly as possible. And as for the advice of counsel defense, I just want to address that briefly because they invoke the advice of counsel with respect to the inclusion of non-lienable items in the lien. And I just want to point out that that is a small fraction of the exaggeration. Even if there was a recognized defense for advice of counsel, we're talking $10,000 of $288,000 in exaggeration. And then I will close with this. That is the expert opinion affidavit of James Marasco, our expert, is so key here in laying out each item of the exaggeration, how to total it up. And there's a very helpful chart on page 1378 of the record that shows exactly every single calculation on a single chart. If this court agrees that there is a lack of a dispute of fact as to any one of those items of exaggeration under the Court of Appeals Goodman case, it must invalidate the lien and award damages and amount to be determined after a trial.
Thank you, counsel.
Thank you.
Morning, honors. Andrew Miller from Webster Zani, appearing on behalf of the respondents. I'll keep my remarks relatively brief. As a starting point, it's fair to say that I completely disagree with opposing counsel's representation of the facts in this case. I'm not going to recite why, but there's been a fundamental disagreement all along regarding the nature of the parties' relationship. These allegations of fraud are completely unfounded, and we intend to make a motion to dismiss against those. Moving to this issue of statutory interpretation, this is really a black and white issue. The lien law, Article 39A, references the word person. How is that statute interpreted? Under Section 37 of the General Construction Law. It's very simple. And the implications of asserting willful exaggeration liability against people who sign mechanics liens is really extraordinary. And you think of it in this context, which is attorneys sign mechanics liens all the time as agents of their clients. Officers of corporations sign mechanics liens all the time. And those who don't have ownership interests. This is really simple. The statute says that the only people who have liability are the persons. Who is persons? It's the legal entity. That's it. Next issue is this effort to bootstrap a tort claim to a statutory claim. You can't do that, right? The statute is black and white. It's strictly interpreted and strictly construed. If you have an abuse of process claim, you can't somehow magically convert that into a willful exaggeration claim. That's not how it works. They're separate claims, separate theories, separate measures of damages. Next issue is this motion for summary judgment. There are innumerable reasons why this motion should be denied. First, there's no agreement as to what the agreement was. There's not a consensus between the parties. Mr. Alexander's affidavit talks about receiving fair compensation. The defendants in this case keep referencing this 10% markup piece. They ignore the entirety of his affidavit. Mr. Mellenbacher has testified affidavit in the record that it was going to be sweat equity. So we don't even have an agreement as to what the agreement is. Mr. Marasco's affidavit offers no opinion as to the value of the work that was performed. All he does is recite what's in the QuickBook records. And then from there, what he does is he doesn't even talk about the value of the actual labor. He takes 10% markup on the payroll costs, not even the indirect costs. His conclusion is preposterous, that 90% of the lien is marked up. We have 7 affidavits that dispute Mr. Marasco's testimony. Importantly, an issue here is that when the judge issued his decision, he also knew that discovery was incomplete. And I have deposed Mr. Marasco since this motion. We have 7 affidavits that dispute the defendant's motion. Then we have the issue of the advice of counsel defense. The record is crystal clear that my clients relied on their prior counsel to file this affidavit. The emails are in the record. It goes to the very issue of willful exaggeration. So unless if the court has any questions, I'll rest on the remaining of my papers.
Thank you, counsel. Case 514 in the matter of the Honorable Randolph Treese. See you, counsel.
Hello, good morning, Your Honor. May it please the court, my name is Jen Flannery. I'm at Barclay Damon. I represent the appellants. In connection with this matter, Your Honors, this is a very simple proceeding in the backdrop of very complicated additional facts. In connection with this proceeding, the only relief that was sought by the petitioners, the appellants, at the trial court level was whether or not Judge Randolph Treese, who's a retired federal magistrate judge, was fit to fill a vacancy that existed in connection with what we call the daughter's trust, the appellant trust. That's a bit of a misnomer because the benefits are in fact to the grantor's daughters and their spouses for their lifetime, but at their deaths, all of the assets go to charities. And there's questions as to whether or not which charities those involve. In 2006, there was a draft that was done by the respondent as attorney who modified the charitable beneficiaries to include a charitable entity to which he was able to direct 1/3 of the corpus. Be that as it may, there's a charitable remainder here. And so in the 4 corners of that trust agreement, assuming for purposes of this argument that the 3rd one is valid, it proscribes a detailed process by which an attorney director can be removed. And the respondent drafted that. Not only did he draft it, he was the one who created this position as attorney trustee. And the 4 corners of that trust agreement say that on the vote of the disinterested other trustees, they can then serve written notice on the trustee for whom the other voting parties are seeking to remove, to include evidence of any of his wrongdoing and the rationale and the breaches and why they believe he was removed. And that's exactly what happened here. And so on December 13th of 2023, the other 2 disinterested trustees had a unanimous vote and served the respondent, who again created all of these procedures and positions for himself as attorney at that point, and served him on December 19th. And there's an affidavit of personal service of that document that included approximately 40 pages of materials about, all of
The same documents, counsel, and just help me with the record, the same documents drafted by this attorney also provided for his replacement or substitution. Did it not? And wasn't he involved in making that determination?
Yes, Your Honor. So the trust agreement itself contained a provision that allowed this attorney trustee, the respondent, to designate his successor. And I believe, if memory serves me correctly, that's Article 5.3b of the trust agreement.
And he did that, did he not?
He did. In fact, in 2014, he named his son, who he was also an attorney. However, I think a very key, important part to consider for the court is that designation, he had to have all of the requisite qualifications and requirements in order to succeed to that role. And most importantly, it had to be reasonably acceptable to the other 2 trustees, Cynthia Doyle and Molly Burns. And that was right within the language of the trust document. And so the other 2 trustees have no recollection of being consulted with or explained by
Do you
attorney.
read the document as saying that he couldn't name a successor until he took the steps to get approval of the other trustees? Or do you read it to say that should he deem a successor and set that up, that the other trustees have an ability to challenge the naming of that successor for the reasons that you've already kind of touched upon?
I don't know that it's that static, Judge. I think like anything, anytime you name a successor, stuff can happen, things can happen, and whether or not somebody remains fit or qualified to act at one point may be very different as to whether they can remain qualified or fit to act, or whether they're reasonably acceptable at another point. He named them in 2014. He didn't procure consent until 2016. And in 2022, they revoked their consent, if it had ever been given at all, and there's questions as to whether that was the case. But at no point in time did the respondent ever then, once the revocation of that consent, for argument's purposes, had been served, do anything. More importantly, the named successor never did anything to this day. The named successor is not a party. He's never been asked to intervene. And his father, the respondent, is seeking to try to enforce alleged or so-called alleged rights that he has with respect to his nomination as a successor. The other two disinterested trustees revoked that consent in 2022, and they did not remove the respondent by that unanimous vote set in that document that he created until December 13th of 2023. So that was 17 months of time. And of course, there's all sorts of other litigation with respect to the other trusts. And at no point in time did he challenge it. At no point in time did this designated successor challenge it. And so once on December 13th, and nor did he, and I suppose this is an important point for the court, nor did he seek to designate anybody else. Since that time that the revocation of consent was circulated and served, there was no other efforts by the respondent to name anybody else or to reaffirm or reappoint or redesignate a successor. And so there was a vacancy with respect to the designation of successor. Consent was not given by the other two disinterested trustees, and they evidenced that and served that. And it wasn't until that he was removed in 2023, December, that all of this started. Now, I think it's important to point out the second department case that's cited in the brief, in principle, the matter of Stewart, stands for the proposition that if within the four corners of an instrument, there is a procedure by which a fiduciary can be removed extrajudicially, that's fine. Then the court has no ability to review that procedure. And then this court in 2023 took it one step farther in the matter of Allen versus Annalette, which is a 2023 case, and said, even if there's a provision that requires a determination as to whether there's been a breach of fiduciary duty. And similarly to Stewart and the Allen case, here, the very documents that respondent drafted for himself when he had no problem enjoying the benefits of the appointment, now all of a sudden are problematic once he's being removed pursuant to those benefits or those provisions. And to say that due process is involved or he wasn't given due process, I think it flies in the face of the entirety of the underlying proceedings. With respect to, again, keeping in mind that the only question that was asked of the trial court was whether or not retired federal magistrate Randolph Johnson was fit to serve, respectfully, trial court erred in the sense that they gave the respondent the ability to intervene in his removal. We never asked for removal. It was never asked. And more importantly, if the court looks at the proposed answer that the respondent attached to his motion to intervene, there was nothing in the answer seeking reinstatement. There was nothing in the answer seeking a declaratory judgment that he had been wrongfully removed. And so with that in mind, he should not be allowed to intervene as a matter of right. We focus a significant amount in our brief on a collateral estoppel component because this is not the first time we're here. This is not the first time that we will likely be here again. Mr. Blair, the respondent, was already removed in a case called the Peter and Elizabeth C. Tower Foundation under identical, materially indistinguishable terms by Erie County Circuit Court Judge Asa Mosey. And in that specific moment, there were several proceedings. Mr. Blair, the respondent in the circuit's court matter, commenced a proceeding to, quote, construe certain pieces of the trust. He commenced a proceeding to be reinstated. And then there was a third proceeding that was commenced to appoint Judge Randolph Treese. And if you look at the removal provisions that are contained in each of those two trust agreements, they have no material differences. You have to serve by the disinterested trustees. You have to serve evidence of breaches. It's so identical and similar that in the respondent's brief, they even conflated the two provisions at one point.
Counsel, so you're saying in effect that he has no more interest and so he shouldn't be allowed to intervene?
Absolutely, Judge. And he's a stranger to this trust. Having been removed, it's fait accompli. He was already removed and the revocation of the consent was already done. And so if you allow a removed party to be intervening, he's really a stranger to the trust at this point. It would open the floodgates for any fiduciary who has ever been removed to come back and have an opinion about some other workings of a trust agreement or a charitable trust at that. And putting aside the inconsistencies in the positions between the fact that Mr. Blair was removed in the Peter and Elizabeth C. Tower Foundation case under similar, and again, that was Judge Randy Treese. We had the same language, we had the same process, and almost identical similar grounds for removal, which are admitted in that proceeding. And
was he removed in 2014? Am I accurate in that, or is that wrong?
Sorry, Your Honor.
He was 2014, he designated his son, correct?
That's correct. So respondent John Blair was removed from his position according to the trust indenture on December 13th of 2023.
Okay.
He was served on December 19th of 2023. The 2014 date is the date on which he appointed or designated his son as his successor. And in 2016, he got the quote consent of the other two trustees that his son at that time was acceptable. And in 2022, that is when they said, he is not acceptable. We are withdrawing our consent, and everybody was served.
Counsel, you should begin to wrap up.
Thank you, Your Honor, very much. I want to mention just a couple of quick items. With respect to the Allen versus Analet case, I suspect that counsel for the respondent is going to raise that vis-a-vis the successor designation. And I think there are three very important distinctions that should be raised with respect to that issue. Number one, that proceeding sought declaratory relief. This did not. Number two, the designated successor was a party to that proceeding. He's not a party here. Jeff Blair has never intervened, never done anything in the half a decade worth of litigation around John Blair and the Tower cases. He's never done anything. And the language of the documents is vastly different. There's nothing that says that he is, that the successor has to be reasonably acceptable to these two people who found that he's no longer reasonably acceptable. One final point, I also think that in their brief, respondents will raise the issue of notice and due process with respect to bylaws of TFFI, indicating that there was a requirement of service for 5 days notice. That provision was the bylaws of a charity that was connected with, but not the Daughter's Trust. The Daughter's Trust, again, was drafted by the respondent, John Blair, who's benefited from those provisions, those very provisions he drafted when it's convenient for him. Those provisions about removal, again, 503B of the trust agreement, are not the same as being removed as an officer under TFFI.
Thank you, Counsel.
Thank you very much, Your Honors. I appreciate it.
Good morning. May it please the court. My name is Eric Kraus of Phillips Lytle, and I represent the respondent, John Blair. Let me start here. The issue in the case is really whether the exercise of discretionary authority by Justice Chimes, a commercial division judge in Erie County Supreme Court, when she evaluated respondent's motion to intervene, was it reasonable for her to determine that, yes, it was appropriate for Mr. Blair to be able to intervene? Despite what you just heard, the facts and the legal issues in this particular case, although they come in the context of much more complexity, but in this case, they're not really that complicated. And it can't be said that Justice Chimes was unreasonable or that she abused her discretion. As the Papa Giorgio versus Con Ed case says, and we cited in our brief, in evaluating the discretion of the lower court to deny intervention in that case, the court said the case does not present exceptional facts showing the court's inability or blatant failure to properly assess the claim. And that is the standard by which this court should evaluate what Justice Chimes did. The appellants, in trying to assert that there's a more rigid standard, cite a 60-plus-year-old case that evaluated the predecessor statute to the CPLR 1012, but it's clear that the standard has evolved over time, and that the two sections, the distinction between the two sections in terms of standard of review has evolved to the point where clearly now courts allow a very liberal standard to allow for intervention in a case like this.
What about the specific statement of your opponent that this was inappropriate because the trustee was removed and that there's no interest? I guess an appeal would have been more appropriate or something.
Well, what my colleague opponent says is that Mr. Blair could start another litigation in another case before a different judge to vindicate his rights. And while that might be true, it seems an extraordinary waste of judicial resources, of my client's resources, to force him to do that when the case, with all the facts, with all the complexities, are now before a judge who understands all those things, in Judge Mosey in surrogate's court, and where the issues could be resolved much more expeditiously. In addition, it has not been fair to Mr. Blair to discharge him, and I'll get to what information was provided to him, to provide him with some pages that allege all sorts of misdeeds on his part without the ability to rebut them. And factually, we disagree with every single claim of any fiduciary failures on his part. It's inappropriate to levy those charges against Mr. Blair and at the same time say you have no recourse in this case. So Mr. Blair is a longstanding member of the bar. He's a well-regarded practitioner in Erie County and in Western New York. For many, many years, at least a decade, he served the Tower family, including the daughters, including Peter Tower, who's the grantor for all of these multiple different trusts that were established both for charitable purposes and for the daughters. And there's not a single allegation that both in terms of investment performance and philanthropy that he ever failed to execute his fiduciary duty. I don't know how anybody can think it's fair to deprive Mr. Blair of the right to be able to rebut the claims that he's violated his fiduciary duty. And I don't think it's reasonable to force him to go to a new court, file new proceedings, when he can do so in front of a judge who's already well familiar with all of the facts and nuances of this case. On the collateral estoppel issue, again, we disagree, counsel and I. There are multiple distinctions to be made between what went on in surrogate's court on this issue and the facts and the legal issues that apply with regard to what Justice Chimes was evaluating. For example, as As the appellants have made clear, this entity TFFI, Tower Family Fund, Inc., is inexorably connected to what's going on with the daughter's trust. We agree with that. And in fact, Mr. Blair was not only the attorney director of TFFI, but he was also an officer. And under the terms of TFFI, an officer is entitled to appear before and be heard by the Board of Trustees of TFFI. He was given no such right under the circumstances that we're facing here. Also, with regard to the appointment of a successor trustee, under the Tower Foundation, which was the first case in surrogate's court, there's no mention to, I'm sorry, there is actually a reference to revocability of that appointment. With regard to the daughter's trust, there's no such thing as revocability written into the indenture. And therefore, aside from whether there could be a revocation or not, it's a very important distinction that the trial court, and now it's Judge Mosey, should be able to evaluate based on facts that are presented to her, which are not even before the court. What is before the court is simply that the indenture for the foundation versus the indenture for the daughter's trust have significant differences. And for that reason, the court should not simply rely on collateral estoppel. And just one quick comment on collateral estoppel. The burden obviously is on the appellants here to show that a collateral estoppel applies. They cannot make a sufficient showing given the differences that I've pointed out and which we've further pointed out in our brief. Lastly, just a word about judicial economy. I would assume that's a matter that this court should be concerned about. And since the case is now pending, as I said, in front of Judge Mosey, Justice Chimes has already ruled on this case, and it certainly cannot be said to be an unreasonable position to consolidate Mr. Blair's concerns about his removal, his ability to challenge the allegations that have been presented to him, that he should be allowed to do so as the current case stands in front of Judge Mosey.
We'll take a look at that, counsel. Thank you.
Thank you very much.
Case 515-516, Aubertine versus Aubertine.
Morning, Your Honor. May it please the court. Dave Healy.
One second, counsel, let your opponent get situated. Sure. And we'll proceed. Thank you.
Good morning. David Ely, Trevec Cristo, appearing for the appellant Vincent A. Aubertine. Your Honor, the issue presented in this case is, did the appellant allege a valid cause of action for constructive trust? The appellant's transfer, his payment of a purchase price, in reliance on a promise of his mother's promise to convey legal title, that's what forms the basis of a claim of constructive trust.
Question, and you know the record much better than I do, but let me just ask this question. I don't see there being any dispute that there was a transfer of funds from your client to his now deceased mother, right?
Correct.
Yeah. My understanding was that your client's claim was at that point on that transfer of money, he was purchasing two separate parcels. One was like the home farm and the other one was a separate parcel. And that, but a deed did not transfer relative to the parcel, right? The separate parcel. Do I have it right so far?
Yes, Your Honor.
Okay, now, here's where I'd like you to address this, because this is, if that's the understanding of the agreement, but that there was some dispute as to, not a dispute, excuse me, there was some lack of understanding firmed up relative to some 5 acres that may be retained by the mother and father at the time, who I think were both alive at the time.
Yes.
That took place,
Yeah.
right? Yeah. So my question to you though is, there's then this subsequent transfer of the parcel property, right? And it's to the brother by the mother. At this point, the father had passed away, I believe.
Correct.
Okay.
Yes.
So if I've got the facts right, at that point, your client is saying, I retain a life interest in that parcel. And that was the understanding we had with my mother at the time.
That's one of the claims.
That's one of the claims.
Life interest is one of the claims.
Yeah. Aren't those inconsistent claims? In other words, I get both parcels with maybe the exception of a 5-acre carve out, which we haven't resolved yet. Or I get the one parcel, the farm parcel, and I get a life estate into the entire other parcel. Those seem inconsistent. And when we're trying to put together a constructive trust argument, don't we have to have some kind of clear communication between the parties as to what was intended?
Yes, Your Honor. I mean, those are alternate causes of action, essentially. The main cause of action is that he paid his parents for this 108-acre parcel.
So that's his factual claim. That's what happened, and he paid for both, with the only caveat being maybe a 5-acre carve out that was going to be worked on after the fact.
That is correct, Your Honor.
Okay, so the second piece that I just talked about, which was the life estate, your client says that has really nothing to do with this, other than I have a subsequent claim because now a deed's been transferred.
Right.
And I'm trying to reserve my rights under that deed transfer, that what was intended by that, even though I don't agree with it, was I still get a life interest.
Yes, I mean, the mother might have been confused. She was not in good health. And so we believe that there may have been additional terms for that transfer, but we do believe that the mother did agree originally to deed the entire title, not life estate.
So that's your main argument, is the constructive trust under both parcels with about a 5-acre carve out, possibly, which never actually happened.
That's correct, Your Honor.
Okay, I think I understand that part.
I mean, there's no question there is a question of fact, but there's a question of fact. My client claims that he paid for this 108-acre parcel in addition to the other home farm.
Now let me get one additional follow-up if I could. With respect to your client's main claim now, then, the first in time that happened, right?
Yes.
Both parcels, 5-acre carve out. Isn't his agreement with his mother at that point? The brother has nothing to do with that, right?
That's correct.
Yeah. And so, but the suit here today before us and before the court below was a suit between the siblings.
Well, we're claiming that that there's constructive trust, that my client paid the mother. The mother was unjustly enriched. And so.
But shouldn't the relief be, and this is where I get a little confused, shouldn't the relief be your client versus the mother, or the mother's now estate versus the son, who was never any constructive trust or agreement with?
But the gist of a constructive trust is that my client is entitled to title to that property, and who's entitled to that property right now is the brother.
But there's no lawsuit against the estate, even though the brother has title. Maybe he needs to be noticed of or be brought in as a party to that. But don't you have to have a claim against the mother or now the mother's estate, or arguably even the father and the mother's estate, now that they're both passed away?
Well, there's no motion to dismiss for failure to bring in a necessary party. The estate has not been probated yet, but essentially the persons who have the interest in the property that my client is claiming ownership of is the defendant. So I think that, I don't know that the estate is a necessary party necessarily, because the person who benefited is the people who purchased the property from my client. But yes.
But your argument is there's no motion to dismiss on those grounds anyway before the court. So I'm reaching here for something that's not before.
That is true. I mean, it was raised in certain points at the trial below, but the court never entertained that as a motion to dismiss on those grounds.
And that's not what's before us.
That's correct, Your Honor.
All right, very good. Continue with her.
Thank you, Your Honor. I will try to be brief. So the matter of Wells case, which is cited by the respondent, is distinguishable. In that case, the sons had not parted with anything of value, their work on the farm, that they had not already been paid for. There's no unjust enrichment. We believe that the court below essentially looked for some type of fraud when they should have been focusing on unjust enrichment. And clearly the mother and the estate was unjustly enriched. She sold the same property twice. So my client paid for it, then she sold it to the son. We believe that the case of Christou and Christou is distinguishable. I think that's one of this court's cases because the transfer of value in that party, and that case was by a third party, not by the.
I'm struggling with something here.
Yeah.
That's, that's a lot of money to give somebody and not even to get, a note on the back of a coaster in return. I paid all this money for something in particular. Now, whether they're averse to going to seek counsel and get a deed written up, which would be relatively inexpensive, but still at a cost, I'm struggling with the lack of any, written purpose for such a large amount of money. Can you explain that to me? Why something is missing, that would be so helpful here?
Well, Your Honor, I think that goes to whether or not there's a question of fact. And I think that's an issue for the jury. That's why summary judgment should not have been granted here. But essentially, we do have and these are farmers. I mean, there's a family. I guess they're figuring they don't need to put anything in writing. We do have the affidavit of Amber Roberts, who was close to the mother, who said that the mother told her that Vincent paid for this property. He gave her the money. So we do not have anything in writing, but I think that goes more to whether there's a fact issue here or not, Your Honor. But it's a very good point. So, Your Honor, we're asking for the court here to reverse the decision and orders which dismissed my client's claims for constructive trust and the order awarding possession of this property to the respondents. The decision below, we believe, is based on, an erroneous conclusion of law. There's no proof in the record to refute the allegations in the complaint or the affidavit of Amber Roberts. We believe my client has sustained all of the elements of a constructive trust. Respondent will get up here, I believe, and tell the court that appellants do not have a valid cause of action because Brenda Aubertine, the mother, never transferred the real property to her son based on a promise. Well, that's not the issue. The issue is, did my client transfer something of value, the purchase price, in reliance on a promise that his mother was going to hold title and give that title to him at a future point? Thank you.
Thank you, counsel.
Good afternoon. May it please the court, I'm Keith Coughlin from Schwarzman and Wise in Watertown, and I represent defendants Keith and Tracy Aubertine. This is a summary judgment review of a dismissal of a constructive trust causes of action in the amended complaint. The defendants met their burden of proving a prima facie case, and the plaintiff only came back in response to that motion for summary judgment of the amended complaint with a memo of law. Because there was no transfer in reliance on a promise in the first cause of action, the fee interest, as a matter of law, there could be no constructive trust claim on that fee interest to the 108-acre parcel. Because the plaintiff,
that he only has interest in the money, not in the parcel.
Exactly, yeah. What Justice Whalen was saying was correct. This is the claim perhaps against his mother's estate or the estate of his parents for $165,000, which we will assume for the purposes of this motion and this argument that he paid. It's a claim against the estate. It's not a claim against the brother for the fee interest on brother and his
Is there
wife.
any indication in the record that there's a dispute as to whether he paid the 165? I kind of read that as not being contested.
It's not contested for the purposes of this argument, Judge. But the claim would be against the estate. What he's done is he's brought a claim against the brother saying, you're a constructive trustee of this property and I get it back. You have to give it back to me. The property was never transferred to the brother for the fee interest. What was transferred was money to his mother in 2009.
So he could bring an action against the estate for specific performance if they had this agreement, but it's not in writing.
I don't think you can bring an action for specific performance in this case. It'd be a claim for the money.
Right, that's all he had.
Yeah. I think that it's important or I should clarify my understanding of the second cause of action, which is a claim for a constructive trust of a life estate. And I understood from the opponent's papers and from the amended complaint that the promise that was made allegedly was by Keith Aubertine, my client, to his mother when he and his wife purchased the property, that Mom, I'll hold this in trust for Vincent. He's my younger brother. I'm older, but I'll hold it in trust for his entire life. And then I'll get the benefit of this 108-acre parcel, which is adjacent to my property. There was no proof of that promise. Vincent on page I think it's 114 of the record, claimed that his brother had made that promise. He had witnesses to that promise, but in response to our motion for summary judgment, he never came forward with those witnesses. He never laid bare his proof to prove that promise. So in the second cause of action for the constructive trust of the life estate, there's no promise that's been proved, and there's no reliance on that promise by the mother that's been proved. There was a transfer in June 2021. The mother conveyed the 108 acres to her son Keith and his wife Tracy, but there's no constructive trust that binds that property.
Is there anything in the record that shows the $165,000 is lying around in the mother's estate somewhere, or is this his only remedy? That all that's available is the land for him?
I don't think that's in the record, Judge. I think it'd be a claim against the estate, though. In many of the cases that we've looked at or that we've cited in our brief, I just wanted to touch on some of those, that there's got to be a transfer. The property in the Matter of Wells case, which my colleague referenced, Farmer Wells in 1971, was alleged to be the constructive trustee of the farm that he had. He willed it to his 8 kids. The 3 sons said, we should get it. Only the 3 boys that worked on the 3 men that worked on the property. The court said there has to be a parting with the property. And in that case, Farmer Wells retained it. So there's no constructive trust on the farm because he never transferred it out of his own title. Recently, in March of 2025, this court in Barker v. Gervera looked at another Justice McCluskey case, or Judge McCluskey case in Jefferson County on constructive trust. And if I could, I just want to mention your words on that one, that a constructive trust is the formula through which the conscience of equity finds expression when property has been acquired in such circumstances that the holder of legal title may not, in good conscience, retain the beneficial interest. Equity converts him, or their claim now her, into a trustee. That elderly farmer case was Barker v. Gervera. We saw the case of Farmer Wells and his 3 sons. And recently, in 2012 at least, there's an elderly step-parent and a residence. And this court relied on Black's Law Dictionary and defined constructive trust as an equitable remedy that the court imposes against one who has obtained property by wrongdoing. Brenda Aubertine didn't obtain property by wrongdoing. She kept her 108 acres. Well, first version, when we heard in the adverse possession complaint, the first complaint in this matter, was that she kept it because she and her husband might want to subdivide the property later. In fact, she subdivided a 2-acre parcel to one of her children, but she never constructed her own family home. She just kept it.
Also, can I?
Sure, go ahead, Judge.
But she did receive property. The money would be the property that she received. It's no dispute that she received the money, is there?
We're conceding for the purposes of this argument, Justice Ogden, that she received the money, and I guess she would be a constructive trustee of that money, and I guess they should sue her estate for that, not sue Keith and Tracy Aubertine for real property.
Counsel, if I could follow up on Justice Ogden's question. So let's put aside, just for the sake of argument, the issue that I raised earlier with your esteemed colleague, the question of are the defendants the right party to have been sued here? Let's assume for the sake of argument that the plaintiff, if this were reversed, the plaintiff were given an opportunity to try the case, and the plaintiff put in evidence through himself that there was an agreement with my 2 parents and I. And the agreement was, as I mentioned earlier, 2 parcels. I get 1 in the deed. The other parcel, I don't get a deed because we're still working out a 5-acre discussion about that. But that property is mine and that's what I'm buying, right? Let's assume for the sake of argument that there's a day in court, it's before a jury, and he is saying that I gave the money and they gave me the 2 parcels, subject to a 5-acre carve-out.
Right.
And the jury believed that. Doesn't that make up a constructive trust relative to the transfer of the property? Because that was the agreement between the property holders and the person purchasing the property, and they were family members.
Justice Swillen, I think your question really is a bit speculative because the property the arrangement was not, I'm buying 2 parcels of property and I'm going to pay $165,000. The TP 584 and the deed says that he purchased 200 acres of property for $165,000, which included a residence, 2 60-stall tie barns, pole barn, equipment, machinery, vehicles, and all the cows. He said in 2009, he said he paid, and we'll grant him this, $165,000 for all of that. And then in his first of 3 bankruptcies in 2018, he pointed out to the bankruptcy court a certificate, which is in the record at 102, that the land and buildings alone were worth $450,000. So there's nothing in their understanding that's specifically referable to this 108-acre parcel. What there is he made a good investment. Allegedly, he was justly enriched for the property that he purchased from his parents for $165,000. So we don't.
There's no proof in the record. Isn't the proof his testimony as to what the understanding was?
It is.
And if a jury were to believe him when he was under oath and testifying before them, isn't that some proof?
But there's no transfer of that 108 acres to a constructive trustee. There's a transfer, as Justice Ogden pointed out, of money to somebody, and that could be the res. That could be what's held in trust.
The argument is there's no transfer of the property at all. But isn't that the whole concept of constructive trust? That the family relationship was such that the parents said, we're going to hold this in trust for you?
The family relationship gives you the confidential relationship. That's one of the requirements if we're going to apply those rigidly. But you're absolutely required by what this court has pointed out in the past to have a transfer or something obtained under unjust circumstances or wrongful circumstances or parting with that property. So I use the word transfer, but a number of different verbs have been used by this court and the Court of Appeals to point out that there's got to be a transfer to create that constructive trust obligation on the person getting.
What would that look like? In other words, if he wanted to do this, what did he need to physically do to make sure that there was a transfer? In other words, what are you specifically saying? You're not saying title, right? Because if there was a title transfer, we wouldn't be here having an argument about a constructive trust.
Well, that's why this isn't a constructive trust claim, Judge. It's really not correctly brought. It's a claim against the estate for money. It's a case of unrealized expectations.
Like, in other words, if this were to be, what are they lacking? In other words, what's your argument? Here's what they're lacking. We need to see something else. Is it writing on a napkin that says, you're going to have this property we're holding in a trust for you, and thank you for the $165,000.
I don't think it's quite that, Justice Whalen. I think that's a statute of frauds type of explanation. I think what you'd have to have, and they tried to do it in the second cause of action, is you'd have to have a transfer in reliance on a promise. So Brenda transfers to Keith 108 acres, and there's a promise that I, Keith, will hold that for my brother's best interest. And that promise Brenda relies on. So we've got a promise and reliance and a transfer. I don't know if there's any unjust enrichment in that case. That's another big part of it, because it's the unjust enrichment and the wrongfulness that really activates, as I think Justice Cardozo put in the case I have in the brief, activates the court's steps here. But that's the type of transfer and reliance that you'd need to make Keith Aubertine, in that totally speculative case, we're just talking here, to make him a constructive.
It's the nature of what we do.
It is. To make him a constructive trustee of the property for his brother's benefit. That I think that Barker v. Gervera case had the same type of facts. It was the old man Barker, farmer Barker, conveyed property to his daughter and son-in-law and believed that he was going to get a life estate back. Having made that transfer to them, he relied on their promise that he'd get it back. But we don't have. So in that case, there's proof of a promise, and this court has twice permitted farmer Barker to keep his case going forward. Here, we don't have any proof of that promise. Vincent, in the record, claimed that he was going to produce these witnesses who heard that promise from Keith Aubertine to their mother, on which his mother relied. There's been no proof of that. And that was their obligation, as I understand it, in a summary judgment case. They're supposed to come back and say, here's something that's a fact. Here's something that the jury should listen to. Didn't happen here, and therefore we ask that this court affirm the lower court's decision in order in all respects, and permit us to go ahead and take full possession of the property.
Thank you, counsel.
Thank you, Your Honors.
Case 517, Canfield Funding LLC versus Focal Point Group LLC.
Good afternoon, Your Honor. Randall White from Connors LLP for the Defendants United Health Group, Optum, and Optum Insight, Inc. And we really have three appellate issues here today. We have our appeal from denial of the motion to dismiss for lack of personal jurisdiction. We have our appeal from denial of the motion to dismiss the fraudulent misrepresentation claim, which is based on apparent authority. We have the plaintiff's cross appeal from that part of the order that granted our motion and dismissed the negligent supervision claim. And obviously I don't get rebuttal, and the plaintiffs had the last word on their
You make your full argument right now.
Cross appeal. So what I'd like to do is start with addressing what I call two of the last gasps that are in the cross appeal reply on personal jurisdiction. Now let me briefly explain what I mean by last gasps. The plaintiff's primary theory on jurisdiction was an agency theory. They said, we've alleged a prima facie case of apparent authority for liability purposes, and that means we've alleged agency for personal jurisdiction purposes under 302. And that's just wrong. It's wrong on the law. As this court has said, you need more than a mere agency relationship to allege agency under the personal jurisdiction statute. And the more is the three-part Courthouse test: awareness, benefit, and control. The complaint fails all three parts of that test, and frankly, the plaintiff doesn't even attempt to satisfy the Courthouse test. And that's important because the plaintiff then can't rely on the New York contacts of the purported agency employees to establish jurisdiction over the corporate defendants. So the plaintiff next turned to 302A3 and said, well, if the corporate defendants committed a tort outside New York that caused injury in New York, they said, we were injured in New York because we're a New York domiciliary and we relied on the invoices in New York and paid from New York. And that's wrong too on the law, because the site of commercial injury under this particular long-arm statute is defined or determined by where the original critical events, and that's a term, occurred as to the case against this defendant. And the cases have said the site is not where the plaintiff relied on misrepresentations or made payment. And the First Department twice in the last 3 years has expressly rejected the idea that reliance on fraudulent misrepresentations in your home state or by payment determines the site of injury. And that's in the Quad Capital and Murray cases. Here are the original critical events with respect to the case against the UHD defendants and their liability for the acts of the employees, whether it's apparent authority or negligent supervision. The original events necessarily occurred in Minnesota. That's where they have their principal place of business. That's where their relationship with their employees was centered. Employee Steiner, who's alleged to have committed hundreds of these false verifications. It's undisputed in the record. He is a Minnesota resident. And so those events, original critical events, occurred there. And so that's why I say that we get these two last gasps. The first one is a reference to discovery, a cite to 3211D, some language from cases that talk about jurisdictional discovery, although I believe the brief doesn't say that they're about jurisdictional discovery. But the short answer is there is no pending request for jurisdictional discovery. The plaintiff didn't make it in the court below, not in their papers, not at oral argument, and it's raised for the first time in reply.
But Counselor, this is a 3211 motion, and and you cite the first department, but the second department said different things too, and just an apparent, exercise of, jurisdiction is enough.
Well, we're talking a couple different things here, Judge, and I'm in terms
Okay,
of.
Go ahead, Claire, go ahead and straighten me out on it.
Well, there are cases that talk about whether you've made a sufficient start that you're entitled to pursue your request for judicial discovery. They haven't made that request in the court below for jurisdictional discovery. I believe they do have to allege a prima facie case of personal jurisdiction, a factual basis for that, even if a somewhat looser standard, but I believe the sufficient start language is when you've made a request for discovery that I believe, and I don't have the cites here, that you can't raise for the first time on appeal. There is no request in the trial court for jurisdictional discovery. And on one level, that makes sense. And that brings me to my next last guess, because all the fraudulent verifications that are at the heart of this case were sent to the plaintiff. They have them. They know them. And in fact, their second last gasp is a theory predicated only on negligent supervision. And it's based on a single email verification alleged in paragraph 37 of the complaint. And that's an email verification of invoices alleged to have been made on October 2nd, 2014 by Rakesh Chandraramani. And the reason they highlighted that is because, according to the complaint, it's alleged to have come from his office in the New York office. And what they seem to be arguing is, well, if the corporate defendant's negligence in supervising Chandraramani is deemed to have occurred in New York or at his office, that's a tort in New York.
But wasn't it more than that? You're saying it was just this one email, but it's the whole, their employment there, what their positions were, what their titles were. Doesn't that all play into this?
Not on this complaint, Your Honor, because there's no allegation of any New York contacts with respect to the defendants other than this email. Now, I'll admit the complaint goes out of its way and doesn't mention the word Minnesota, but there's no allegation of, we know from the record, it's undisputed that Steiner, who committed hundreds of these verifications, was a Minnesota resident. And they hang their hat on this one email, and we can argue about whether the negligence occurred in New York or not, and that's debatable. But there's no way that this case arises from that email, even for purposes of personal jurisdiction. And the reason is, if you look at paragraph 59 of the complaint, they make crystal clear what their claim is. The claim is for, quote, unpaid invoices dated July 1, 2019 through August 26, 2019. And they give the amount, $3,603,170.71 to the penny. They term it, quote, open accounts. And that figure is repeated throughout the wherefore. And that makes sense, and they provide the explanation. The fraud was discovered in September 2019. And these were the invoices where they're left holding the bag. But you can't say that the claim for those July, August 2019 invoices arose out of one email verification sent 5 years before by an employee who is only alleged to have sent one of the verifications. Even if you want to look back and say, well, some of the prior verifications are relevant, maybe it's related, hundreds from Steiner. He's a Minnesota resident. That's undisputed.
Well, they have a statute of limitations problem. Obviously.
Well, they do, and I'm going to rest on my briefs on that because that would only get me partial dismissal, Judge. So we think and that's why their two last gasps, I think, don't work on personal jurisdiction. But let me turn then to fraudulent misrepresentation and apparent authority. If there's one thing that was drilled into my head in law school, it's that an agent cannot create its own apparent authority. It has to be the acts of the principal. And what that means, and I'm trying not to just simply repeat our briefs here, is that the plaintiff can't rely on the actual words of the purported agents. And it also means when we're looking at this motion that in determining whether apparent authority was created, the court cannot rely on acts or words of the purported agents. It has to be the acts or words of the principal. And so the briefing is kind of teed up a little bit of a procedural disagreement or confusion here. We believe the acts or words of the principal is essentially a different element of the apparent authority claim. The plaintiff in their briefing tries to, in our view, mush it together with reliance for several reasons. But the point is, we think it should be, in essence, sorted out by the equivalent of a motion in limine at the outset. Because when you come to whether apparent authority is created, you can't look to the acts or words of the purported agents. But even if you somehow subsume it in the reliance analysis, you still have to take out the acts or words of the principal when it comes to whether apparent authority has been created. And here, the bottom line is the only acts or words of the principal here are the job titles and the general areas of responsibility. And factually, that makes sense because there never was any business relationship between the UHG defendants and the plaintiffs. None. Now, we pointed out the cases that say job titles, indicia of employment aren't enough to create apparent authority. But even if you say there's been some apparent authority created, it still has to be with respect to the specific transaction at issue in the lawsuit. And that's a critical element. It makes sense because it's just the result of the basic principle that even if you have some agency relationship, it doesn't create apparent authority on the part of the agent to bind the principal without limitation. And so we cited the cases, the Edinburgh Fire Department case, standard funding, that talk about the specific transaction at issue requirement, which is very strict. No response from the plaintiff. To this day, they haven't mentioned the Edinburgh Fire Department case, and the court below are here. Here, the specific transaction at issue is the verification of vendor invoices and accounts receivable to a third party with whom United Health Group had no business relationship whatsoever. And so,
this question, the vice president, Hansen, right, confirms the existence of the debt and confirmed that Steiner was the appropriate contact person at UHG Optum. Isn't the vice president Hansen someone with the authority to bind the corporation? Or is that just not enough?
No,
to
because
demonstrate that?
You're right in that it all comes back to the same job titles and areas of responsibility of all four. Because if Hansen doesn't have the apparent authority, him designating Steiner doesn't do it. Just like when they say to the plaintiff says, well, Steiner confirmed he's the person. Well, and that brings us to the whole idea of the specific transaction at issue requirement and these general areas of responsibility. And again, if you compare the Edinburgh Fire Department case and standard funding, what was found insufficient in those cases in terms of the area of responsibility or the job title, insufficient to convey apparent authority with respect to the transaction at issue, much closer than this case and still not good enough. And of course, obviously the case that is directly appropriate is a Foot Locker case. And that's where the first department said that the employee's title, Director of In-Store Marketing, was not sufficient as a matter of law to create an apparent authority to verify invoices from the in-store marketing vendor.
And remind me, was that a 3211 case also?
Yes, yeah. And they said the title was insufficient by itself to convey authority over accounting matters. And that's the same thing here, Judge. There's nothing about that would convey authority about accounting, accounts payable, anything like that. And there's a very, if you take their theory, although it's not articulated this way, that any job title or general area of responsibility conceivably related to that topic would create apparent authority. And so it's really like an umbrella. We use that. If the plaintiff can say, well, my transaction somehow kind of falls under this general umbrella, if I can find a way to do that, there's apparent authority. And there's a couple things that
Counsel, you should begin to wrap up.
well, that flips the burden on who has apparent authority. And apparent authority is the ability to bind the principal. They're trying to bind them here with 3.6 million. Any employer then has to say, wait a minute, I just put this title in some areas of responsibility. Anything remotely close to that, I may be on the hook for. When it comes to negligent supervision, if I may, we have two arguments here. One's much simpler and direct, and that's a lack of notice of propensity. There's no allegation here of any behavior or conduct or propensity of the four employees, Steiner, Chandraramani, Hanson, and Boyd. The complaint does allege, though, that United Health should have been aware of, quote, Mann's proclivity as a con artist. To state the obvious, Michael Mann, the fraudster, isn't any of these four employees. He was never an employee of United Health. And I'm not aware of any case, New York case, that says you can satisfy the requirement of notice, prior notice of the employee's propensity for the same conduct by referring to notice of a different person who is not an employee. That's certainly asking the court to make new law. I'll rest on my brief on the choice of law, but let me add, Judge, this brief conclusion. You know, we've said a couple times that the complaint here as United Health is the attempt to fit the square peg in a round hole. And let me tell you one look based on the complaint as to why that makes sense. I said United Health Group and plaintiff had no business relationship. The plaintiff and Michael Mann did. They did business for over 6 years. Plaintiff bought hundreds of invoices from Michael Mann, presumably at a discount. And for 6 years, the plaintiff received full payment on those invoices, not just his money back, but their profit, millions. Now they got caught when the music stopped. They're left with 3.6 million. And the bottom line is they're trying to stick the United Health Group defendants with that 3.6 million based only on some alleged job titles and responsibilities. And that's why when they try and justify those claims, they're forced to take positions in the briefs that are simply just wrong as a matter of law, or essentially ask the court to make new law. So we request that we dismiss the complaint its entirety as to the United Health defendant.
Thank you, counsel.
Good afternoon, Your Honors. May it please the court. May it please the court, Ed Markarian for the plaintiff. Your Honors, where an employee commits actionable conduct in New York as an apparent agent of the employer is liable in New York, and the employer is subject to jurisdiction in New York. The agency question is a thread that runs between both the substantive issue and the long-arm question, and that's the best place to start. At the beginning, counsel mentioned the Kreider versus McFadden case, and that case does not apply. It has nothing to do with this case. Kreider did not involve employees. Kreider did not involve apparent agents. In Kreider, the Court of Appeals set forth the test for determining whether a non-employee is the actual agent of an out-of-state principal. Has nothing to do with this case. This case involves employees. Employees are, to start with, the agents of their employer. Now, they can step outside of that agency, but they're still liable if, when they do that, they have the apparent agency. And the apparent agency is created by a totality of circumstances. The defense wants you to look at snippets, but even the snippets they mention are very compelling. But you need to look at the totality of the circumstances to see if these employees had an apparent agency. A parent agency is judged by what it is reasonable for the third party to believe based upon the acts and the omissions of the employer. So what's the totality here? First, it's the job titles, which has been discussed. And as noted, Steiner, and remember, they're verifying IT staffing invoices, IT staffing. Steiner is a director for staffing and financial analysis. Hansen is a vice president for IT delivery and vendor management. Chandramani is located in New York City, and there's a fourth verifier, Mr. Boyd. So you've got 4 fraudster employees making these verifications with job titles that indicate they have the authority to make the verifications. So that's step 1 on the totality. That might be enough, but there's more. You heard about the VFP versus Foot Locker case. Well, the court noted in that case that there was no way for the employer to know about the frauds. Well, what's another part of the totality here? In this case, the plaintiff wrote letters, not to the verifiers, the fraudulent verifiers. They wrote letters directly to the defendant saying, hey, we're taking assignment of these. Is there a problem with these? Please let us know. And the defendant stayed silent. Also on the totality, you have to consider that if something happens once, maybe you can forgive an employer, doesn't know about a rogue employee. If it happens twice, 3 times, 4 times, this happened just to this plaintiff hundreds of times over 6 years, and it wasn't the only victim. P2BI, another company in Colorado, went through the same thing. And there's a notice to the FBI that makes us wonder if there's a third victim here. So this is 6 years, hundreds of fraudulent verifications by 4 employees with at least 2 victims. And again, it's acts or omissions of the employer. The cases say the employer can't close its eyes to what's going on. The cases say you have to look at who's in the best position to prevent what's going on. And I don't mean to over dramatize this, but I think it's fair to say that these defendants created an environment where fraud was running wild. And who should be responsible in that situation, especially when we're considering the case on a 3211 motion? Should we be able to get into the courthouse to figure this out, where this degree of fraud is going on for so long with so many victims? Are these employees acting with apparent agency? I submit for 3211 purposes, it should be accepted that they are. So that brings us to the long arm question. And 302 says that a defendant is liable, or there's jurisdiction for a defendant in New York for the acts of its agent. So if these fraudsters are agents of the defendant, then that's a basis for jurisdiction. So what are the 3 subdivisions of the long arm statute to look at? 302A1 is transaction of business in New York. A single transaction is enough. The Deutsche Bank case says, when you're electronically transporting or transmitting into New York, that's a transaction of business. They're doing it hundreds of times. They're verifying invoices. The definition of a transaction of business is purposeful activity. Obviously, that's purposeful activity of a business nature. The plaintiff sure thinks it's a business transaction. He's relying on it. So that provides jurisdiction under 302A1. 302A2, there was a lot of discussion about, they're saying that Mr. Steiner lives in Minnesota and that's the end of the story. That is not the end of the story. We know Chandramani is in New York based on his email signature. That Steiner lives in Minnesota is not conclusive. These defendants are a massive corporation. They have offices in New York. We don't know if he's in New York transmitting some of these emails, and there's a reason to question that he might be, because the kingpin of this whole operation is located in New York. That's Michael Mann. So Steiner never comes to New York to perpetuate any of these events. The other thing is the Justice Department thought it was in New York because they prosecuted Steiner and Mann in the Northern District of New York. So there's enough on 3211 to think that there's jurisdiction to get into the courthouse with respect to a tort committed in New York. If the tort's not committed in New York, then we're under 302A3, tort committed outside New York with an injury in New York. And the defense argument is there's no injury in New York, which obviously just at a gut level doesn't seem right because the plaintiff never went to Minnesota. He's been in New York the whole time. How can the injury not be in New York? And there's a long line of Second Circuit and New York District Court cases applying 302A3 that says in a fraud case, which is what we have here, the situs of the injury, the original critical events, is where the plaintiff writes the check because that's the injury. There's a whole line of cases. There's one New York case that goes with that. They're saying that there are appellate division cases that go the other way, and I disagree with that. The Stone case, the original critical events were the plaintiff going to Africa to engage in the safaris and ask for them to try to give him trophy status. He literally goes to Africa. They said those are the original critical events. You heard the Quad Cities case mentioned, but Quad Cities was more recently analyzed again by the First Department, who said, what we said in Quad Cities, what we were really trying to say is that the plaintiff in that case was just fortuitously in New York. The plaintiff here isn't fortuitously in New York. It's the only place the plaintiff has ever been. So that's a basis for finding jurisdiction under A3, certainly on a motion to dismiss. And lastly, we've cross-appealed, Your Honors. The fraud cause of action was correctly sustained. On the cross-appeal for negligent supervision, that should be reinstated. At the court below, plaintiff argued that we can't decide negligent supervision yet because there's a case pending at the Court of Appeals, more charitable. And in the court below, the primary argument of the defendants was that based upon the appellate division decision in more charitable, there should be a dismissal because there was no customer relation between the defendant and the plaintiff. That went up to the Court of Appeals. The Court of Appeals reversed in more charitable and said, no, you don't need a customer relationship. So that argument now goes in plaintiff's favor. The alternative argument of the defense is that plaintiff didn't plead propensity, didn't use the word propensity. But New York is not a jurisdiction where you have to say a magic word. You have to plead facts. And the facts of the complaint here overwhelmingly show propensity. The propensity in more charitable was one prior incident. Here we've pleaded hundreds of prior incidents. Propensity is a tendency to do something. Well, if they've done it hundreds of times, that shows that there was a propensity that the defendants should have known about, and that satisfies that pleading requirement. And lastly, they say that on conflict of laws, Minnesota law should apply. That's not true. The difference between Minnesota law and New York law is conduct regulated. In Minnesota, you can only recover for a personal injury. In New York, it's personal injury or economic damages. That's different elements of the tort, and that's a conduct regulation, which means the site of the tort controls, which, for choice of law purposes, is where the last incident causing injury occurred, which is New York. So the negligent supervision cause of action respectfully should be reinstated.
Thank you, Counsel.
Thank you, Your Honor.
The last case on for argument today, case 518 through 520. Held versus Cheektowaga Sloan Union Free School.
Good afternoon, Your Honors. May it please the court. Tiffany Lopez, appearing of Dan Chacha Attorneys on behalf of the appellant Celeste Held. We are here on appeals that relate really to one single jury verdict that was rendered after trial. Starting with the argument really by the plaintiff that this is an illogical and irrational verdict and must be set aside. It starts with some of the evidence that did not make it in front of the jury. There was a pretrial motion in limine, and plaintiff was prevented from having two witnesses testify. They were two classmates of Ms. Held during the year that she was abused. Now, I'm going to sort of head this off in saying that this case is about abuse that happened, 50 years ago. And we all know the difficulty in evidence that comes along with proving cases like that. In this case, it is interesting and compelling that when the plaintiff's counsel got this case, the plaintiff's investigation was able to locate 5 witnesses, 3 of whom are from a 6th grade class that were, 2 years before the plaintiff was abused, and two of whom were her classmates in the same year she was abused. So that's 5 witnesses from 50 years ago, 5 students who were willing to testify on behalf of someone, that they have in a matter they have no interest in. So that's not usual in cases like this. And so for the plaintiff to be prevented from having 2 of her own classmates testify and provide some context about the pervasiveness of Horny's, this teacher's behaviors, was
The
critical.
purpose of the evidence of those 2 witnesses was for notice, constructive notice?
Partially, because it did go to constructive notice, certainly, because if you recall, we have this, in a 6th grade student, Deborah May, a couple of years before that. It's misleading too, because she made those reports about how creepy Horny was at the end of her 6th grade year. And then we have this happening at the beginning, really within the first 4 months of Celeste's 4th grade year. So it's 1 full school year. There's some proximity here. This isn't some removed, very remote time period where Deborah May made these complaints and then 5, 6, 7, 8, 10 years down the road, now, one plaintiff is abused. She made her complaints. There were also 2 classmates in that 6th grade class that were able to.
In the same class as the plaintiff.
There's 2 of the same class as Deborah May when she made those complaints about, Horny's behaviors, the sexually charged innuendos, the games that he was playing. And there was also we found 2 witnesses the same year of the plaintiff's grade who were both abused before the plaintiff. So it would go to constructive notice. It would also go to level of supervision.
Even if the reports were made after the period of time that the plaintiff was abused?
Yes, and this is what's critical here. And I think that the trial court really focused on, the district had no actual notice. And really, the personnel file from Mr. Horny was devoid of much information at all. So we can't say one way or the other that they didn't receive notice. But for purposes of this, at least of these 2 witnesses, we concede they did not have prior notice of these incidents. However, Horny's behaviors were continuing after Deborah May's complaints that, 2 years before, a year and a half before.
Didn't they move him? That's what they did. They moved him.
They moved him from the 6th grade now to the 4th grade. Part of our argument was, of course, to a more vulnerable population. There was no notation in his file at all, not only after the complaints were made by Mrs. May, but also why they moved him. They didn't even have his grade assignment for the 6th grade. They didn't have his grade assignment for the 4th grade. They didn't have any notations in there that there was any observation period, that they checked in on him. There was no performance reviews. I mean, there's just.
That's why they moved him, or did they just move him in the ordinary course of assigning teachers?
We don't know, because that's one of the things that's just not in the file. We don't have that information. Again, 50 years. Without that information being in the file, the district had no witness to tell us why that happened.
And these witnesses were not going to, I think that's what the lower court didn't want to have these witnesses because they weren't witnesses to any abuse of the plaintiff.
They were not witnesses to the abuse of the plaintiff, but the 2 witnesses that we were intending to call, Nancy Storr and Michelle Ederer, they were classmates of Celeste Held. And they were abused in that same 4th grade class before Celeste Held. So again, when you take.
But let's stay there for just a second.
Yes.
So I can understand your argument at least. So they were abused before the plaintiff in this case.
Correct.
Right? But I think the record reveals, and this is where you need to correct me if I'm wrong, that those 2 witnesses did not put anybody on notice that this was taking place prior to the plaintiff's abuse. Right?
You are correct.
Yeah. So that's why you're getting to the constructive notice.
Correct.
And your argument is this was taking place. And with proper instruction, the jury should have heard these witnesses, and then the jury could decide whether or not the school administration knew or should have known that this was going on, and therefore that's why this testimony would have been relevant for the plaintiff's claim in this case.
Correct. And furthermore, there was an issue again about the window coverings on the window door. I believe
The door being locked.
the door being closed. These are 9, 10-year-old girls.
Okay.
They're students. They're being asked to stay after class by their teacher. They stay and then they're abused. And the fact that, again, this tiny little time period in this fourth grade class, there's 4 months of this fourth grade school year. And we know that 5 girls were abused. So the fact, again, let's set aside the actual notice, but the fact that conduct was being allowed suggests certainly that he was not being supervised, that no one was monitoring his classroom. They weren't doing check-ins. They weren't leaving the doors open. He's doing it on school premises while these students are in the custody and control of the district.
So your argument is that the school district knew, school district should have known.
Should have known.
Okay. Can we move on though
Yes.
past the two witnesses that you thought should have testified? And let's get on to the finding of the jury and the jury verdict with respect to a finding of negligence, but not a finding of proximate cause.
Yes.
I'm saying they're intertwined, that those two claims, you can't have a jury find negligence and have a jury find not proximate cause because there's no factual scenario that would allow for that to happen. And therefore we need a new trial on both negligence and proximate cause.
Correct. Absolutely. I mean, Your Honor, the issue here on negligence and proximate cause is so inextricably intertwined under the facts of this case. We know that there are cases where it's not.
Okay, can I ask you a question on that though?
Yes.
Did trial counsel make that argument when the, at trial before, when the verdict sheet was, or the, requested charge were laid out? Because I mean, what you know now, you would have known that, or and getting a separate verdict on a proximate cause happens more frequently than we want to. It happens.
Absolutely.
But it had to be foreseeable that would happen in this case.
My understanding of the law, Your Honor, is that it's really a weight of the evidence argument. It's slightly different in that you have these two issues. Once the proof goes in under the facts of this case, they become inextricably entwined, whereas you can't have a finding with one without the other. But really that speaks to the weight, because what is the evidence that went in front of the jury? In this case.
But hold on a second, Justice Greenwood, I think it is saying, look, if you're saying this was intertwined, this was a fact that was known before the jury got the case, that this was intertwined. And if that's the case, why wasn't there a request by plaintiff's counsel for a charge to the jury that you can't find negligence without finding proximate cause? Or if you don't find negligence, you find negligence, you're done. If you find negligence, you have to find proximate cause. Why was there not a charge or direction to the jury for that, if in fact in this specific case, the two were intertwined?
Because I think that would have gone too far in making those decisions for the jury.
So you're saying though that the jury verdict goes to the jury with the possibility that they could find alternate decisions, yes on negligence, no on proximate cause, even though the facts of this case do not allow for that. Do you see what I'm struggling with?
I see what you're saying, but where I think that is not the case here is because, as the trial court, and I think counsel would all agree, that the trial court's view of this was, if the jury does not accept the testimony of Deborah May, then we get no further. Because the jury is not going to have any evidence whatsoever.
Was May being offered for proof on negligence or proximate cause?
For notice, so it would speak to negligence. And again, at this point, we did not have the benefit of the two witnesses that we were intending to have speak also on the issue of notice and negligence. But my understanding, Your Honor, is that notice is a prerequisite for negligence.
Counsel, are you saying that if we find that the two witnesses were properly excluded, then you concede the second argument, because without them, you can't get to both negligence and proximate cause?
I'm not conceding that, but what I'm saying is because we only had Deborah May available for testimony in front of the jury, the trial court was of the opinion that if it really all hinged on the jury's acceptance of Deborah May. Because if Deborah May's allegations are disregarded by the jury, there is no notice, there is no negligence, and we don't reach any further conclusion.
Why would it be wrong for the jury not to believe that there was, Mr. Horny was acting in an inappropriate way and that there could be constructive notice there, but not believe the abuse took place? Or say that on the proximate cause issue, that it was a criminal act and therefore we're not holding them responsible as a proximate cause, as a line of reasoning. Not that we necessarily would say we'd agree with it, but in the deference, we're supposed to get to a jury verdict to a certain extent.
Absolutely. But like in the Victoria H case that is cited in our brief, where there was, in that case, there's a sexual assault by a fellow student. It wasn't by a teacher. Okay. And in finding similarly there, when you're looking for negligence against the school district, the issue is whether or not they could have done something different. They should have known about it and then could have taken action to intervene or to prevent it. They are responsible for putting this teacher into the classroom, and that therefore exposes these students to harm. So it's a situation where the jury was asked to answer. We're assuming questions that the jury wasn't asked to answer. The jury was asked to answer specifically on the verdict sheet. Was the school district negligent in retaining, supervising, and directing Mr. Horny? They weren't asked if the school district was negligent in supervising Celeste, which was part of one of our causes of action. And if we are going to assume that in your example, they felt that, okay, it's a criminal act, and the school district's not responsible. It happened on school premises while Horny was administering his employment. He was teaching the students, asked them to stay after school. So that would have been an inconsistent verdict in terms of what the facts showed. This isn't a situation where, okay, the jury finds, okay, there's damages, but we're going to award 0 damages. This is where on the significant, factor issue, the jury was asked to decide whether or not the school district's negligence, failing to supervise, failing to direct, failing to, negligent in retaining Mr. Horny, was a cause of her being abused. It no matter how slight or how trivial. So I think the inconsistency and the irrational portion of the verdict is that we would have to assume facts that the jury was not, assume questions that the jury wasn't asked.
How slight or how trivial, it's a substantial factor, but there can be multiple substantial factors.
Yes, but even to some extent, if the district's negligence is a cause, even if it's to some slight extent, that would still be a substantial factor. So they could still find that even if it is not overwhelming or the primary cause. And I think that that's really where this, becomes one of those situations where the overwhelming evidence in this case, really did preponderate in favor of the plaintiff. Because here you have a 9 or 10-year-old girl in 4th grade who has no understanding or knowledge of what this teacher's history is. But the school district had already received at least one actual complaint about this concerning sexually charged behavior and failed to do anything in response to that.
Counsel, you should wrap up.
Okay. And so, again, in this case, it's not about just the pure volume of evidence that the plaintiff had. It's also about the quality of evidence that they were, that we were allowed to submit. I understand that there's those 2 witnesses, but even notwithstanding that, we had an expert, Dr. Coppola, who did give an opinion that said that it was irresponsible for the school district not to take further action. This 9-year-old was not she was not responsible for her own care. The school district should have been, the school district should have been, asked, and the jury should have been asked to decide whether or not the school district was also negligent in supervising her, which they were not. So for those reasons, we would ask that this jury verdict be set aside. Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. Kevin Cope with Bond, Shenick & King on behalf of the defendant respondent, Chickamauga Sloan Union Free School District. This Child Victim Act appeal boils down to plaintiff's disagreement with a jury verdict following trial. Plaintiff had her day in court, presented all relevant evidence to a jury of her peers, and that jury dismissed her case against the district, finding that the district was negligent, but that such negligence did not proximately cause the plaintiff's abuse. Continuing to prosecute this appeal, plaintiff fails to recognize the exacting burden placed upon her in seeking to overturn a jury verdict. Plaintiff's appeal falls into two categories: that the jury's verdict should be overturned against the weight of the evidence presented at trial and in the interest of justice. And each of these categories has a high threshold for overturning a jury verdict, which the plaintiff has not met here. First, I'll go to the against the weight of the evidence at trial argument. Plaintiff principally contends that the jury's verdict was against the weight of the evidence at trial because negligence was inextricably intertwined with proximate cause, as your honors have recognized. However, the negligence case law provides that negligence is not automatically inextricably intertwined with proximate cause, and same with the Child Victim Act case law, that negligence and proximate cause are two separate issues for the jury to consider.
Are you saying that they can never be intertwined?
No, Your Honor. I'm saying that it's a factually intensive inquiry, and it's seldom found that negligence requires a finding of proximate cause. They are traditionally two separate analyses. And here there's facts in the record that demonstrate the jury did in fact look at these two issues separately. As the trial court recognized at page 22 of the record, the jury underlined the word substantial in the jury verdict sheet. It found negligence and then determined whether or not the negligence that it had found was a substantial factor in causing the plaintiff's abuse, firmly demonstrating that it was a separate analysis that the jury undertook. The case law firmly support, or the facts of this case firmly support that as well. As plaintiff's counsel recognized, the abuse occurred in January of 1971, and there's no dispute that there was actual notice of the abusing teacher's propensity to sexually abuse students prior to that abuse. Plaintiff relied upon constructive notice at trial, and that constructive notice came in the
So why don't you get in, what's the valid line of reasoning the jury could have followed to find no proximate cause based on this record?
Sure, Your Honor. And here, as plaintiff recognized, they presented principally the testimony of a liability expert, Dr. Coppola, at trial to say the district did not react reasonably to Ms. May's report. It should have further investigated this report. And plaintiff's assumption is that had it properly investigated this report, that it would have led to information or action that would have prevented the abuse at issue. Plaintiff's expert didn't specifically testify as to what the required course of conduct was, however, that would have prevented the abuse at issue. What he did testify to was a menu of options that the district could have taken in response to this report, including that had it investigated it and properly responded, it could have gone to do administrative leave of this teacher, it could have provided more in-service training, or it could have provided counseling. But the liability expert never then went on to say any one of those or collectively definitively would have prevented the abuse at issue in this case. That left the jury free to conclude the district might have been negligent in failing to respond properly to this report. It should have further investigated it, but that had it further investigated it and properly responded to it, counseling or in-service training wouldn't have led to a series of events that would have prevented the abuse at issue. And that goes to one thing that plaintiff's counsel has stated, is that they feel that they've demonstrated that the district's negligence was a cause of the abuse, but the case law provides it has to be a substantial cause in order for there to be proximate cause. There's a conflation between factual cause and proximate cause in the plaintiff's analysis. And they failed to demonstrate either at trial, in the record, or on appeal that the district's, the facts presented at trial demonstrate the district's negligence in failing to investigate this report further or respond to it necessarily substantially caused the abuse at issue. And we heard earlier about the Court of Appeals decision in Nellenbeck that demonstrated that the reasonableness of the response is measured by the reasonableness of the status quo at the time that the actions happen. And plaintiff's expert provided that reasonableness in terms of saying the court could have permissibly provided more further in-service training. The court could have provided counseling, and the jury was free to determine If that reasonable response had occurred, it wouldn't have prevented the abuse at issue. So the jury's verdict in specifically analyzing negligence and proximate cause here is supported in the factual record before the court. Turning to the plaintiff, I mean, to note on plaintiff's contention that the evidence so preponderated in her favor that it's illogical for this jury's verdict to have been reached. The jury did reach that verdict. That's the fact, and it's been upheld by the trial court finding a rational basis within the record before the court. And for the reasons that we just discussed, that there was a logical basis for the jury to find negligence without finding proximate cause. So the evidence did not so preponderate in the plaintiff's favor at trial. Towards plaintiff's second category of collateral attack on the jury's verdict, the interests of justice, they primarily contend that the preclusion of Nancy Storr and Michelle Ederer was a prejudicial exclusion to their case. Pre-trial, plaintiff solely contended that these two witnesses were relevant to the issue of whether or not plaintiff was abused. In other words, that because plaintiff's testimony was hers, plaintiff's sole evidence of her abuse was her own testimony, that other witnesses that were alleging abuse as well would bolster the fact that she was in fact abused. The plaintiff cannot demonstrate prejudice through the exclusion of these two witnesses on that basis because the jury did in fact find that the plaintiff was abused. So there's no prejudice there. Plaintiff now shifts the argument slightly to contend that these two witnesses were relevant to the issue of constructive notice, that this was abuse that was there to be seen and that the district should have seen it. But they never follow up with answering that question of why the district should have seen this. As your honors noted, neither of these witnesses came forward and said this abuse was occurring. And in the proposed testimony from these witnesses, there's nothing that would have been a tripwire for the district to further investigate or to further look into that would have provided the district further notice of abuse occurring in the classroom that would have prevented the abuse at issue. So these two witnesses, the fact alone that they were abused is not constructive notice. There must be something more that demonstrates and ties their proposed testimony to the constructive analysis that would.
There's some facts in the record about the windows being covered.
Yes, Your Honor, and that was evidence that was presented by Miss May in her sixth grade year. The plaintiff, in fact, never testified that the windows were covered.
The doors were closed when he was alone in the room with young female students.
Yes, Your Honor, that is what plaintiff testified to, is that the door was closed at the time of her abuse. That in and of itself, there's nothing to demonstrate. So stepping back for a second, the constructive notice that's alleged here relates to the activities inside the sixth grade classroom during the day. There's no evidence that the district was on notice that this teacher was meeting with students after school or was meeting in closed door meetings with these students after.
And that's your point. Your point is that, look, even if those things happened, that they still weren't on notice. And there would have to be a lot of testimony that this was going on day after day after day after day to the point where the administration would have to know, have to be alert. They can't turn a blind eye to things. But you're saying it didn't reach that level yet. All we have in the evidence before the jury was a couple of isolated instances, which didn't get to the level you needed to get to for constructive notice to be applied here. Is that what you're saying?
Exactly, Your Honor. The fact that this is new conduct, this isn't conduct that had been complained of or the district had been put on notice. If this had been something that occurred in the classroom, for example, during one of these games that Miss May thought was inappropriate, during the detective game or during the moonball game, that would be something that the district should have looked further into and would have been notice of. But there was no evidence
that this case went to trial. This isn't a summary judgment motion. So the court allowed this testimony about notice and all, and the jury made a finding. That's really not what this appeal's about.
If I apologize, my argument came off wrong. I was contending that the notice that was presented at trial did not relate to after school closed doors meetings with students. There was no notice to the district of these types of conduct, the type of conduct that plaintiff alleges occurred that led to her abuse. So essentially what plaintiff is contending in this appeal is that the district was required to monitor all activities of this teacher, not just the ones that it was made aware of at trial with the evidence at trial through Ms. May's report. This is different conduct that occurred in a different setting because it was something that was after school with closed door, locked doors.
So you're saying that's why it's not inextricably intertwined because of that reason? Is that what you're arguing?
Well, that goes more towards the prejudice that plaintiff is contending, is that they were precluded from presenting these two witnesses at trial, and those two witnesses would have gone to constructive notice. But the constructive notice of what is the question that remains pending. And the constructive notice the district was provided with through Ms. May's testimony did not reach the issues that led to the plaintiff's abuse. So there was no constructive notice that would have been allowed through their testimony.
Any further, counsel?
No, Your Honors, thank you very much for your time.